Good evening, everyone. We're here this evening to hear cases for the City of Deltona Code Enforcement. I'm the special magistrate appointed by the City Commission to hear those cases. The first thing we do is we identify ourselves, those folks that are here on behalf of the city. And I always start with myself. My name is William Reichman. I'm an attorney. I've been doing this for the City of Deltona for a couple years now, and I've been an attorney for almost 40 years, doing most of that time with local government work, including code enforcement. So we're going to go around the room and identify all the code enforcement officers, and I'm going to start on my right and ask everyone to identify themselves.
My name is Mark Gibson, Code Compliance Supervisor.
Myron San Miguel, Hearing Clerk.
Danny Ron, Code Compliance Supervisor.
Jeff Gaffney, Code Compliance Officer.
Kristen Coulter, Code Compliance Officer. Taylor Seacup, Code Compliance Officer.
Steve Rockoff, Code Compliance Officer. Dennis Hughes, Code Compliance Officer. Todd Mead, Code Compliance Officer.
Marion Larissy, Code Compliance Officer.
Bashir Turkzy, Code Compliance Officer.
Tyler Russo, Code Compliance Officer.
Josimar Jimenez, Code Compliance Officer.
Jose Garcia, Code Compliance Officer.
Janice Pulaski, Code Compliance Officer.
Richard Lubbock, Code Compliance.
Marcia Siegel-George, City Attorney.
Thanks, everybody. I think that's it. At this time, if we could stand and pledge allegiance to the flag. If you join me.
Pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
All right, thank you, folks. We're here tonight to hear a whole bunch of code enforcement cases brought by the City of Deltona for compliance or alleged non-compliance with code. These hearings are what are called quasi-judicial. It means that we're not setting policy. We're applying the codes to properties. This is not like a courtroom. It's not that formal. It's pretty informal. The formal rules of evidence under Florida law do not apply, but we're going to follow fundamental due process. And that means that you receive notice of not just of the hearing, but of the violation under Chapter 162, and you also will have an opportunity to testify and tell me, and I'm going to be the finder of fact, what you want me to hear about your case and whether you agree that there's a violation and what you need as far as dealing with that, or if you feel there's not a violation, then you can tell me that too. You have the right to present evidence, and as any witnesses that you've brought to testify on your behalf. We are recording everything today, and in a second I'm going to have everyone stand up and make sure that your testimony is under oath, and that includes the representatives of the City of Deltona. These are public hearings, but they're not public. Excuse me. It's a public meeting, but we don't have public comment. It's not like the City of Deltona City Commission meeting. These are just your cases and the city's cases. So we're not going to have an open forum. So in order to speak tonight, you have to have a case in order to testify. The way this works is the city goes first. They've got the burden to prove that there is a violation, that they complied with all the procedural requirements under Chapter 162, and they're going to come forward and they're going to speak right at that big podium right there. And then when they're done, what I need, then we'll call you guys, and if you could speak over there. And so the city goes first, and when they get done, then I'll ask someone who's here on this particular case to come forward and to speak. With that, I want to make a couple statements. I think it's important for you all to understand that one of the things that's absolutely essential for you to know and for the city of Deltona to know is that I've not spoken with any of you, and I've not spoken with any of the code enforcement officers. So when you come before me, when the city comes before me, this is first impression for me. I have not made up my mind. I couldn't make up my mind because I haven't seen any of the evidence yet. So I want you to be assured that whatever happens this evening will be based upon what I hear tonight, and therefore it'll be what you hear tonight. So what that means is that I've had no what's called the legal jargon ex-parte communications. I have been provided and reviewed the agenda for this evening, and as well as the minutes from the last code enforcement special magistrate meeting, and approved those. A question for staff. Under announcements on the agenda, there's a lot of cases that have been withdrawn and continued. Are those listed for the folks to see, or have they been advised whether their case has been continued or withdrawn?
Yes, sir, those have been listed for them to see on the agenda, and they have been.
Very good. I'm not going to announce them then. So with that, let me go ahead. I think we need to get everyone sworn in. So if you would stand and raise your right hand if you testify this evening, please. If you're going to provide any testimony this evening, I need for you to stand and raise your right hand. Do you swear or affirm that the testimony you provide this evening will be the truth, the whole truth, and nothing but the truth?
Will do.
Thank you very much. When it is your time to come forward and speak, what I'm going to ask you to do is just come to that podium right there, and if you could, for the record, this is important, so because they're recording it, like I said before, I need your name and your address, and then you and I can talk about your case. Okay, so the first case tonight, as was mentioned to you before, we try to do this first come, first serve. So with that, first case is, looks like there's two cases, and they involve 22-177 and 22-178, 2123 Saxon Boulevard. So if you give me a chance to get to that. Okay, Officer Muse. These are two cases, two different cases. Remember, sir, we'll get to you in a second. Just going, you're fine, you're fine. It's why I didn't, city goes first. And this has to do with two different cases, same property, 2123 Saxon Boulevard, Deltona, Florida. And the first case is 22177, which is roof and flashing, and the second case has to do with what we call blight here. So, Officer Muse, is the city ready to proceed?
Momentarily.
Okay. This looks like it's a commercial property, Expert Car Care 3 LLC. Let the record reflect that there is a representative here for the property owner, and we'll have that person identify themselves in just a second. I'm just stalling.
Yeah. Sorry, sir, I'm trying to get my pictures up. I can't get a, yeah. Oh, that might be wrong. Doesn't show it. Yeah, I guess I'm going to have to do that. All right, Mr. Ishman. 177. Okay, my name's Dennis Muse. I'm employed by the City of Deltona as a code compliance officer, and my credentials are on file with the city. This is a case number DEL 22177, City of Deltona versus Expert Car Care 3 LLC. Location address is 2123 Saxon Boulevard, Deltona, Florida 32725. Parcel ID number is 80230112080. Violation of City of Deltona Ordinance Section 18-5, which adopts the latest edition of the International Property Maintenance Code. Section 304.7, which states the roof and flashing shall be sound, tight, and not have defects that emit rain. Corrective action would be repair or replace the roof, gutters, or drainage. The statutory requirements for notification of this hearing have been met by a notice of hearing was sent certified mail 10 days prior to the hearing date, posted at the property address listed with the tax collector's office. The notice of hearing was also posted at City Hall at least 10 days prior to the hearing. All the evidence of this case, including photographs, have been marked as exhibits and submitted to the Code Board hearing clerk. I certify any and all photographs to be true and accurate portrayals of what I observed the day they were taken. The facts of the case are this case is a proactive case that started out in February 7th, 22. This is an old gas station that was closed up for several years. When I stopped at this location, looked through the windows, found the ceiling coming down in quite a few areas. A notice of violation was mailed out the next day and returned to City Hall on the 22nd unclaimed. On and about 3/15/22, spoke to Gamil Gowney, had called and stated they were working with a company in Tampa to make some repairs and would require 6 more weeks to possibly get the work done. On May 30th, 2022, nothing had been done. Hand-delivered the notice of hearing to an Amy in the front office at this location in a separate building on 7/13/22. As of right now, the city is recommending 60 days to come into compliance or a fine in the amount of $250 a day thereafter. On this one here, as far as the pictures go, this is the inside of the unit, and as you can see, the ceiling is coming down. It looks like either I guess it would be part of the ceiling that came down. Racks, there's food or boxes on the floor. The rest of the ceiling, there's insulation coming down, and this is all the pictures. That's my notice posting for a notice of violation.
So the property remains in noncompliance tonight?
As of today, the property is in noncompliance. I did have a couple pictures, basically the same thing.
And as far as the time frame for compliance, what is the city's recommendation?
60 days or $250 a day.
Okay, we'll handle this case before we move on to the next one. Is there someone here for Expert Car Care 3 LLC?
Yes, James Sada, representing Expert Car Care 3 LLC.
So we're just talking about the roof on this one, sir. So tell me what you need me to hear on this one.
Well, they kind of coincide with the second part.
I'm having a hard time hearing
Sorry,
you.
they coincide with the second part of the violation, the second one. Last year we had a semi truck come underneath and tried to go underneath the building, and it took out the canopy or broke it. So what we've been doing is this insurance claim, and we can't put a new lease in there with it being fixed. So we did an insurance claim. The insurance, if you can imagine, they took their sweet time and just kind of took forever. Once we got the insurance done, we had a company called Aluminum Plus to actually come out and fix the whole building the way it should be, so that we could put a new tenant inside there. They ran out of employees. They didn't have materials, and they had like a short staff of employees. So that took several months. We dropped that company, and I have a new company that we've actually hired back in February that I've already paid for. We're just waiting for them to show up, but we can't get anything. We can fix the inside, in the meantime, but we can't put a new tenant in there until the canopy is fixed.
A couple questions for the city or for you, sir.
Yep.
I'll start with the city. This property is not occupied at this time.
It is not occupied.
There's no tenant in there.
No, right now, no.
And this case is just about the interior.
Just about, well, pretty much the interior, which would
And that's the one I think you just said, sir, that you've got a contract for.
Correct.
Okay. So the city is saying that it would like to have the inside fixed in 60 days. And I get it. You had to do it through insurance, but now you've got the insurance done. So that's a check. You had to get another contractor. You got another contractor. You said you got them in February. It's now July. So I don't, my job here is not to set you up for failure. But on the other hand, my job is to create a little incentive for your company to get going on fixing this, because it is a code violation. So I want to find out what's reasonable. So this has been going on for a while. So You tell me, 60 days, you're going to be able to get it done?
I think so. The issue is we're kind of at the mercy of the companies. The first company, Aluminum Plus, they dropped the ball and they kind of disappeared. So we had to get another company. Like I said, I have the invoice and everything that I've already paid for, but that was back in February. So I'm waiting for these companies, and there's not many companies that could do these type of fixes, especially for the canopy. So I've done my due diligence. We're trying to pay. We've done everything we can. We have them in contract. I'm kind of just at the mercy, and with the inflation and everything that's going on right now, and the materials, I think everyone's having a hard time getting things fixed, and the short staffing. So I can't make excuses for them, but I'm hoping that 60 days will be enough to be able to get this done. Like I said, I'm already in contract with them.
What do you think, if they show up, we're not looking at months and months and months to fix this. This is like a week to fix it?
A week, not even. Like
Couple
5
days?
days, like 5 days, 4 days to even do the whole job. Yeah.
Okay. It sounds like 60 days is enough, just got to get them to show up. So
Yeah.
if I incentivize you, then you'll incentivize them, and maybe we'll get this fixed then. So what I'm going to do is I'm going to find that here's my ruling, that the property is still in violation. I think we all understand that. The pictures are clear. You agree?
Yeah.
We agree that 60 days is fair. And I'm going to say that the fine will be $100 per day.
Okay.
So again, that fine is not to punish you, it's to incentivize you, sir, because we don't want your money, we want the property brought in compliance.
I
Fair enough. But if it doesn't, then the fine will start running. And so I just wanted to tell you, there is a stick as opposed to a carrot involved in this process, and we prefer not to use the stick.
I appreciate it. Thank you.
All right, so it's $100 per day, 60 days to comply. All right, the next case is DEL 22178, same property, different violation. This one's called blight. City, ready to proceed?
Yes, sir. 1 second. Okay. Again, my name is Dennis Muse. I'm employed by the City of Deltona as a code compliance officer, and my credentials are on file with the city. Case number DEL 22178, City of Deltona versus Expert Car Care 3 LLC. Location address is 2123 Saxon Boulevard, Deltona, Florida 32725. Parcel ID number is 8023-112-0080. This is a violation of City of Deltona Ordinance Section 3710, public nuisance, which states that all blighted and industrial properties are hereby declared to be public nuisance, the abatement of which is pursuant to the police power is hereby declared to be necessary for the health, welfare, and safety of the residents of the city. Corrective actions: obtain a demolition permit for the unused structure or bring the structure back to current codes. Statutory requirements: and notice of hearing was sent certified mail 10 days prior to the hearing date and posted at the property address listed with the tax collector's office. Notice of hearing was also posted at City Hall at least 10 days prior to this hearing. All the evidence in this case, including the photographs, have been marked as exhibits and submitted to the Code Board hearing clerk. I certify any and all photographs to be true and accurate portrayals of what I observed on the day they were taken. This, again, was a proactive case. This one here started on 5/31. This is an old gas station, again, that it was closed up for several years. While discussing this case with my supervisor, Supervisor Ron, to go ahead and move forward with the anti-blight ordinance after showing him some of the photographs that were taken previously. As stated in the previous case, on or about 3/15/22, Gamil Gowney called stating that they were working on with a company in Tampa to make some repairs. Again, it would require 6 weeks possibly to get the work done. That call was taken by Officer or Supervisor Ron. As of this date, nothing has been done. Hand-delivered the notice of hearing in violation to Amy in the office of this location. And that was on 7/13. Again, we are asking for 60 days and $250 a day. The outside, a different story. As you can see, this is the part where the semi hit the post. The back side of that. Again, the overall appearance of the property is nothing but shade for U-Haul trucks. But then again, there's a lot of damage to the building. It looks like places where it's separated.
Has the city inspected this what we're looking at right now for structural integrity or danger to the public?
Not that I'm aware of, no.
Okay. Same situation though. There's not an active tenancy in there.
No, sir.
So right now it's just there's trucks, U-Haul trucks parked underneath it.
Yes, sir.
Okay. Anything further from the city?
No, sir.
Okay. Go ahead, sir. If you could identify yourself.
James Sada, representing Expert Car Care 3 LLC.
So let me tell you what my concern is about this one. I mean, we've got some aesthetic concerns. We need to get those fixed up. This one's a little different because it's outside, and I can't tell, and you heard what I asked the city, whether there's a potential that thing looks like it's pretty big and pretty heavy. So have you had it inspected?
By the companies, yeah, that were for the repair.
So what did they say?
They said it needs to be removed.
So, but I mean, until it's removed, are we looking at that thing strong? We get big storms come through here. I mean, could it fall down?
There is possibility for sure.
Yeah.
I can't speak for them, but yeah, I would say that's the reason why we put the U-Hauls there so that nobody can go underneath them. For right now, we're waiting for the company to pull to do the permit to
get it fixed.
You see where I'm headed with this?
100%.
I mean, and I'm sure you're worried about it too.
Yes,
Because
very.
you could have someone sleeping underneath there, or
Yeah.
kids playing. And I don't like to be pessimistic, but too cynical, but that thing falls down under, people are getting cover when it's raining real hard, and that thing comes down from a gust of wind. And, I don't want to have to read in the newspaper about that, and I'm sure you don't either, because you own the property, and your name will be on or your company's name will be on the lawsuit. So,
Yes.
So this one I'm a little bit more concerned about, obviously.
Yeah.
So where are you in the process of getting that thing fixed and made safe?
I've already paid for it, the full demolition process. I have the receipt, I have the contract, I have everything for it. That was back in February. I'm still waiting for this company to come out and do it.
Okay, so when was the last time you talked to him or nagged him or told him, hey, get out here, I paid you?
The past 3 days I've been on them since.
What'd they say?
And that they're trying to get somebody out this week. Not this week, the following week.
So what do you think, how quickly can you get this fixed?
I think if they come out next week, the whole thing, including both violations, will be done in 4 to 5 days.
Okay, I'm gonna be a little bit more stringent on this one.
Sure.
And I hope you understand, I didn't.
Safety.
It's safety.
Yeah.
I just worried about that. So I'm gonna say that we'll give 45 days for compliance.
Okay.
Or a fine of $200 per day.
Okay.
Because those are the only two things I've got to use to try to get this thing
course.
done. So you know where I'm coming from on this
Of
one.
course, I see it. Yes.
Okay, all right. Is there anything further on these cases?
No, sir.
Sir, you understand where we are?
Understand.
Okay, good luck. I hope you can get those people out there. It looks like this, at the very least, I would want to get that done starting tomorrow morning.
Yes. I appreciate it. Thank you.
Okay. Okay, next case. 22-2112-1071 Joel Court. Hang on a second, let me find the case. Okay. Officer Laracy, you all set?
Yes, sir.
Please proceed.
Thank you. My name is Marion Laracy. I'm employed by the City of Deltona as Code Compliance Officer. This is in reference to case number DL22-212, City of Deltona versus Torres, Carmela, and Myra N. Property address is 1071 Joel Court. Parcel ID number is 813-040-530-080. This is a violation of City of Deltona Ordinance Section 37-10, public nuisance, which states a blighted and distressed real properties are hereby declared a public nuisance, the abatement of which pursuant to the police power is hereby declared to be necessary for the health, welfare, and safety of the residents of the city. The corrective action was to fix or replace the walls or the roof and or remove the tarp. Statutory requirements for this notification of this hearing have been met. By notice of hearing and notice of violation were sent certified mail to the property owner at the address listed with property appraisers. In addition, both notices were posted on the property at City Hall at least 10 days prior to this hearing. All evidence in this case, including photographs, have been marked as exhibits and submitted to the Special Magistrate Clerk. I certify any and all photographs to be true and accurate portrayals of what I observed on the day they were taken. This is a proactive case that actually began quite some time ago, May 2021. I left notice, went through the process August of 2021. I've been in contact with Mr. Torres. He explained to me that they're in litigation with the roofing company and has an attorney involved. I do have paperwork from a public adjuster, and there is an open case in the clerk of courts involving, the insurance company. We are requesting a 90 days for the property to come into compliance or a fine of $100 per day.
Just curious, the 90 days, what's the rationale for that?
I guess we're just in hopes that maybe it would help push along his
Okay.
case that he has in the clerk's office.
Mr. Torres?
Yes, Carmelo Torres, 1071 Joel Court.
So you've heard what the city has to say, and I've you can listen very carefully.
Okay.
They're saying the property's still in violation. Those are the current photos.
To my knowledge, the only thing is pending is the roof, and it's in litigation right now. I had no control over. When I first got the case, we asked for an extension, and they gave me a year. They still in court. I got a letter from the lawyer explaining why they're still active. So the only thing I believe I'm here for is, unless she says something different, is for the roof situation, and it's in court. I had no control over. I just asking for another extension. When it can be done, I do not know. I'm at the mercy of the court system, and if it was for me, it would have been done yesterday. But I can't do much about that.
Okay, a couple questions.
Yes, sir.
So the photos that we're looking at here, Mr. Torres, those do accurately reflect what your house looks like right now?
Well, on the roof, yes. The rest of it, what do you imply on that?
I think we're only here on the roof, correct?
On the roof.
the
Just the roof.
The tarp roof.
Just the roof.
Yeah, just the roof.
When I ask a question, it's just about the roof?
Yes.
Okay, so is the tarp, who installed the tarp? Was it the roofer? Did you?
No, the Biohome. Biohome is the company that put
Okay.
that's the one that came in.
And it's been out there for over a year on your house. Do you have any leaks?
No, with the tarp, no. And it looked like that now, but it's not. If you got the picture recently,
Yes,
on Sunday,
I took a
it's not
picture
like
today.
that, because every so often I have to go back there and get somebody to put tarp and put new bags to keep it up more like that.
Yeah.
That's the way it looks now.
Well, I think we all agree on what the situation is. It's just that this thing's been slowed up. You probably don't want the tarp on your roof either. You
I hate it.
Yeah, of course, and I get that. So, but we do need to, for the sake of the neighborhood, your neighbors, and yourself, create a little incentive. So, and they're not here today, but the lawyers, do they say that you're set for trial, or do you know where it is in the court system?
Yeah, she printed out the proceedings.
The last I checked, looks like April 27th, there was a notice to appear by Matthew Adams Esquire, and then State Farm. That was the last thing that was in the.
All right. Well, it doesn't sound. If they're just appearing, then you got a ways to
Yes.
go. Then that's what it looks like to me. So I'm assuming that underneath that tarp, there's a lot of work to be done.
Yes, it is. If we take the tarp off, we'll probably see the reflection of the water.
And is the purpose of the lawsuit to get you some money so you can fix your roof?
To fix the roof, yes.
Okay.
It's because the insurance covered me, and then all the years that I've been with them, they collected and only contacted me when the increase went. And all of a sudden, they magically say the act of God, they don't cover, and the policy says they cover hurricanes and storm, which it was an act of God to begin with. So I really don't understand how this is going to be, but I check around, and if you check State Farm, they have pretty much about 50-60% cases on running that they don't want to pay.
Let me ask this question, sir.
Yes.
Have you got an estimate from a roofer what it's going to cost to fix your roof?
Yes. With the shingle, it's going to be $36,000.
$36,000.
Correct.
Okay.
And then, it's
So let me ask this question. It's a rhetorical question, but what if you lose the case?
I'm going to have to make a loan or something.
Right.
I have to, at that point, I had to make a decision what are we going to do. But until then, if I do anything different, I threw out the window what I paid for the 10 years.
Here's my dilemma. Mm-hmm. I understand your situation. You're caught between a rock and a hard place, but this thing's been going on for about a year and a half. Mm-hmm. That means that your neighbors have been looking at that tarp, just like you have. They've been living with it for a long time. And it looks like this case could drag on, and I'm a lawyer, so I know how I litigate. I know how these cases can go for a long time. If I say to you, well, we'll give you enough time until the lawsuit's finished.
Once the lawsuit's finished, I will take care one way or another.
No, I know when the lawsuit's finished, but we don't know when that lawsuit's going to be finished, do we?
I honestly don't have a clue on that because I had no control over the
I wouldn't even ask you. It'd be impossible for you to answer that. So I've got to come up with a reasonable period of time for you to fish or cut bait, to either fix it yourself or hopefully get the lawsuit resolved. The city said 90 days. How much time are you asking for before you get this thing fixed?
I just met with a guy in Sanford that owns a construction company. And when he heard about my situation. I said, man, I hope you don't have to be in this situation. He's been going on for 2 years. And he has money to put the roof. I don't. So that will answer your question?
Well, you didn't, no, not really, but I mean, I'm asking you to tell me how much time you need before we start imposing a fine on you.
I cannot really say, because if I tell you 90 days, I will be making a wild guess, because if it's taking a year, God only knows if it's going to take 6 more months. So I'm really caught in the hard situation.
No, I know. All right, here's what I'm going to do. You know, obviously the property's been in violation for some period of time, and I understand your situation. It's definitely difficult. I'm going to give you 120 days. That's basically 4 months. Try to get this resolved so you can fix the roof, or a fine will start of $100 a day. So what that means in practical terms, in my opinion, I'm not your lawyer, is that you need to let your lawyers know.
Well, I have a letter from him here.
No, but you need to let them know that this went to a code enforcement hearing.
Yes, I did. That's why he provided me a letter to give to you.
But you need to let them know what happened at the code enforcement hearing. And that the code enforcement officer, special magistrate, gave you and therefore them 120 days to get this thing resolved. So that's putting a little bit of incentive, a little bit of a fire, lighting a little bit of fire under your lawyers to try to get this thing done. Fair enough?
Honestly, the time, I don't think it's something that's feasible to be met because of the length it's been taking. But if incentive is the word, then I don't see any incentive for me. I'm the one that is getting to pay the fines at the end of the day. I'm probably sure that I might not be the only person in Deltona who runs in this situation.
Oh, I'm sure you're not.
You know, and
we have
so I don't know
cases like
what
this
to
before.
ask as far as time, because I don't have a clue on that. I had no control.
And
of
I
the system.
appreciate that, but with the city of Deltona and your neighbors can't wait an indeterminate amount of time for this property to get fixed up. So my order is going to be 4 months, 120 days to make progress. Please keep in contact with the code enforcement officer. That's really, really important. Let her know what's going on.
We've been keeping in touch completely.
Yes.
Okay.
Every time she come over.
Sounds like y'all are working well together, and I appreciate that. City appreciates that. So 120 days. Just keep that in mind. Please mark on your calendar and see if you can get some progress made on this.
Let me ask you something, because this is the first time I've been put on this situation. I'm used to see bullets coming from one side, but now they're coming from everywhere. So this is what I'm asking. At the end of the 120 day, the court don't have anything. The lawyer can do anything. I'm stuck with $100 a day for the remaining until I can get it done? Is that where we at?
That's what it would work. That's correct. And I can't tell you what to do, but you said that, I did ask you a question, what happens if you lose the case? And you said you'd have to go out and get a loan. So what you might want to do, and again, I'm not your attorney, I'm not giving you advice, but if it looks like you're not going to be able to get this thing resolved, you might be able to try to just go out and get a temporary loan, fix the roof, and then when the case resolves, go ahead and pay off that loan with the proceeds of the case. But again, it's not my job here to tell you how to comply. My job is to tell you as far as the time frame for compliance and then the fine. And I've done that tonight.
Okay, now let me ask you something, if I may. So it's coming down to the day, and I had no way to make the resources come through. What is the incentive for me? Do I have to take the tar, patch it up with tar, any way I can to
coordinate
prevent?
that with the code enforcement officer. This lady right here, I know you've been working with her. She'll answer that question for you, okay?
No, but my question could be to her, but the answer comes from you. So if that comes to that, I'm going to try to see if it's a way that I can get around that to be able to comply the best way I can if I cannot come up with the resources to do it. Because at that time, I don't think she had the power to impose what you impose for the incentive.
No, she doesn't. But if the property isn't brought in compliance in 120 days, the fine will begin. And at some point in time, you will be back here to quantify that fine. It's called a Massey hearing. Obviously, none of us want to do that.
Right.
So it's important as you get close to the 120 days, if that's what happens, that you coordinate with the code enforcement officer where you are, okay?
So that means whatever we come up with that we can get around it, he'll let you know, and then you let me know if the deadline comes.
Again, as I said at the beginning of this meeting, I don't have communications with code enforcement officers between these hearings, because that would be inappropriate. It would be an ex parte communication. So again, I need you to coordinate with this young lady right here. And thank you for being here tonight, sir. I need to move on with the next case, okay?
Okay, thank you.
Thank you. we've got two cases, same property, 22218 and 22219. The address of the property is 1131 West Page Drive, and the property owner is Mr. Vargas. The first case is 218 and has to do with a permit, and the second case also has to do with a permit. And Officer Meade, city ready to proceed.
1 second to set up these pictures. Yes, okay. Okay. My name is Todd Meade. I'm employed by the City of Deltona as a code compliance officer. This case number is DEL 22218. The City of Deltona versus John Vargas, Jr. The property address is 1131 West Page Drive. The parcel ID number is 813055240010. This is a violation of the City of Deltona Ordinance Section 18-3, adopting the latest edition of the Florida Building Code, Section 105.1, which states that any owner, authorized agent who intends to construct, enlarge, alter, repair, move, demolish, or change the occupancy of a building or structure, or to erect, install, enlarge, alter, repair, remove, convert, or replace any electrical, gas, mechanical, or plumbing system, the installation of which is regulated by this code, or to cause any such work to be done, shall first make application to the building official and obtain the required permit. Corrective action for said violation is to obtain a permit for the wood structure at the entranceway to the home. Statutory requirements for notification of this hearing have been met by the notice of hearing and notice of code violation were sent in certified mail to the property owner at the address listed with the property appraiser's record. In addition, both notices were posted on the property and at City Hall at least 10 days prior to this hearing. All of the evidence in this case, including the photographs, have been marked as exhibits and submitted to the special magistrate clerk. I certify that any and all photographs to be true and accurate portrayals of what I observed on the day they were taken. On March 1st of this year, the Code Office Compliance Officer visited the property of 1131 West Page Drive and observed a wooden structure at the entranceway to the home that had been constructed. I made the attempt to contact the homeowner and notify them of the required permit for the walkway platform. A door hanger courtesy notice was left. Later, contact was made with the homeowner to direct to obtain the permit for the wood platform. I talked to the homeowner over the phone a couple of times while they prepared documents for permit submittal. Homeowner was unable to submit documents for the permit application when the specified time and the notice of violation was issued on April 6, 2022. The review of the property search and city records did not show any issued permit for a wooden structure at entranceway. The city would like to request 30 days for the property to come into compliance or a fine of $50 per day to be imposed until such time that the property owner has notified the city of compliance.
I'm sorry, just how many days again?
30 days, please.
What was the fine?
$50 per day.
Okay. First question, sorry, it probably sounds stupid. You've got two cases here, both involving permits. I presume that there's a different structure improvement with a different permit required for the next case?
Mostly a permit, the wood fence that was erected.
Okay, so this case just has to do with this, what we're looking at right here, which is that wooden walkway.
Wooden walkway.
This next case has to do with something completely different on the same property, which is a fence.
Correct.
Okay, thank you. Just need to understand that. So, Mr. Vargas?
Yes, John Vargas, 1131 West Page Drive.
So we got you're a handy guy? Looks like.
Yes, I own a remodeling company, so that's what I do for a living.
So we need to get a permit.
Yes, well, I've been on a roller coaster with this incident. So when they told that I needed to get some blueprints for that walkway, I talked to the, architect. There you go, I'm sorry.
Okay.
Architect. And when I talked to the architect told me, how can I give you some blueprints on something that's not attached to the house? So when I showed him the pictures, he says, all you did was just a walkway. So that's when I came back over here to the city. I came back 3 times to the city, which my name should be on the list. And then when I told him that, the supervisor, he's over here, the supervisor right there, he told me, hey, you're correct. You don't need a blueprints for that because it's not attached to the home. So that came out of the way. And then I brought him an old survey. And then when I did my new survey, that's what they were waiting for the fence.
We're not talking about the fence right now.
Oh yeah, I'm sorry. So then on the survey,
just these steps, these
correct.
wooden steps.
So on the wooden steps, it's already on my survey. I got a new survey. They were booked out for a while, so I just finally got to do the survey. And then I was told through my wife, she told me, hey, they came over here, drop off some paperwork. They said, I told them that you already had the survey. And then I told them I want to show up. I'd rather just show up instead of bringing the survey so that way they can cancel this court meeting today because I wanted to present what I had and I wanted to say a couple things for my property.
Okay, so let me make sure we're all on the same page. You've finished the work, that's what it looks like.
Yeah, that's what well, I'm not finished yet, but that's what it...
Okay, that's what it looks like.
Yeah.
And we need to get a permit for it. Haven't got a permit yet, but you're making progress to get a permit.
I got it on the survey already.
I got it, I heard you. So what the city's saying is they're not really arguing with that. They're just saying we need to finish the process. And what they're asking me to do is give you 30 days to finish that process.
Yeah, but I was told to get a survey first and then do everything together. That's what I was told by the officers.
Well, everything together, does that mean is that for the fence too?
Because I also had to pull out another permit for the stucco, and then I told him, I said, look, I just went to Castleberry, pulled some other permits, and then I was told I wasn't supposed to pull a permit for stucking, and then that's when
We're not talking about stucco, we're not talking about Castleberry, we're just talking about the city of Deltona. And I'm just trying to understand, there's 2 different permits needed here. One is for the steps and one is for the fence. And what the city's saying is that they think 30 days is fair for you to get the permit for the steps. Okay. And I'm asking you if you agree with that.
Oh, I can get the permit tomorrow. They were just telling me they wanted the survey. They told me to do it all in combined once.
If you can get it tomorrow, then 30 days is going to be more than enough, isn't it?
Oh, yeah.
Okay. So I'm just not trying to, like you heard me say before, I'm trying not to set you up for failure. So that's why I'm asking you. So yeah, that's great then. So what I'm going to find is that the property does need to come in compliance. How? Get the permit.
Correct.
30 days to do so. You can do it tomorrow. Okay. So if you don't do it within the 30 days, it'll be $50 per day. Okay. I don't think we're going to have a problem with that.
No.
Okay. So we're done with that.
Correct.
Now we're going to move on to the next case, which is 22-219, which is a fence. Okay? Hopefully it's the same situation, maybe not, but let's just go ahead and wait and hear.
Okay. My name is Todd Mead. I'm employed by the City of Deltona as a code compliance officer. This will be case number DEL 22219. The City of Deltona versus John Vargas Jr. The property address is 1131 West Page Drive. The parcel ID number is 813055240010. This is a violation of City of Deltona Ordinance Section 18-3, adopting the latest edition of the Florida Building Code, Section 105.1, which states that any owner, authorized agent who intends to construct, enlarge, alter, repair, move, demolish, or change the occupancy of a building or structure, or to erect, install, enlarge, alter, repair, remove, convert, or replace any electrical, gas, mechanical, or plumbing system, the installation of which is regulated by this code, or to cause any such work to be done, shall first make application to the building official and obtain the required permit. Corrective action for said violation is to obtain a permit for the wood structured fence. The statutory requirements for notification of this hearing have been met by the notice of hearing and notice of code violation were sent certified mail to the property owner at the address listed with the property appraiser's record. In addition, both notices were posted on the property and at City Hall at least 10 days prior to this hearing. All of the evidence in this case, including the photographs, have been marked as exhibits and submitted to the special magistrate clerk. I certify any and all photographs to be true and accurate portrayals of what I observed on the day they were taken. On March 1st of this year, I visited the property at 1131 West Page Drive and observed a new wood fence that had been erected. I made the attempt to contact the homeowner and notify them of the required permit for a fence. A door hanger courtesy notice was left for the resident. Contact with the homeowner was made with a direction to obtain a permit for the fence. I talked to the homeowner over the phone a couple of times while they prepared documents for permit submittal. Homeowner was unable to submit the documents for the permit application within the specified time, and the notice of violation was issued on April 6, 2022. A review of the property search and the city records did not show any issued permit for a fence. The existing chain link fence was replaced by the new wood structure. The city would like to request 30 days for the property to come into compliance, or a fine of $50 per day to be imposed until such time the property owner has notified the city of compliance.
Okay, this one's just about the fence.
Yes, sir.
Just need to get a permit.
Correct.
Mr. Vargas, what say you?
Well, I know they were telling me about the fence, that it had to be 5 feet. From what I was told when I did the survey, the gentleman said that the reason, I guess what they told me was they consider my house a two-face because it's a corner lot and you can turn it either the way how it is now, or I can turn it sideways. I don't agree that I should cut it down, a foot down. I have cameras all the way around the house, and I see people trying to overlook at my property. And then when I just got my new survey, I just found out that the neighbors behind me are still in 10 feet from my property, so the gate's gonna get pushed back, the chain link. And then all I did was the chain links that was there. When I purchased the house, I only purchased the house for a couple months. Did a lot of changes, put a lot of money into it. And then the gate, it was a metal chain link fence. The pipes were all coming off. The kids, they can get hurt. So what I did was I just put the foot fence. If you look at the pictures, it's only from that side right there, which was already existing, and then it goes to the side, the other side, there you go, right there. So that L shape right there, that's the only thing that I did, but it was already existing, and that's why I had a buddy of mine, he's a GC, he told me, hey, if it was already existing, you don't need to pull a permit because it already exists. All you did was repair it with something different. Now, the city of Deltona is a little different, so I just found that out when I had to come over to the city.
Okay, so it looks like you did a real nice job, but that's not the dispute this evening.
Okay.
The issue is you got to get a permit.
Yeah, I'm going to pull the permit already.
So, and I think we're all in agreement.
Correct.
You need to get a permit.
Well, the reason why I couldn't get the permit was because they were requesting a survey. And Todd was the one who told me, hey, the lady from the office told me you need to get a new survey because it was a 30-year-old survey.
And you got that?
The new survey, yeah, I got it today.
Okay, so you should be able to take the new survey, go back and get your permit.
Correct.
So they're saying 30 days for you to go back and do that.
Okay.
Kind of like the last case.
Yeah, the last case, I know. Like I said, I just got my survey a couple days ago. So the survey was already done but I already know that this is going to become
okay.
Probably
it sounds like this should be no problem for you to go and get the permit within 30 days. So that's what my determination is tonight. The 30 days is reasonable, a reasonable period of time for you to go and finish what needs to be done, which is get the permit for compliance. And otherwise, if for whatever reason you don't do that, then there would be a fine imposed after that of $50 per day. But that doesn't sound like that's going to happen.
Okay, that's fine.
All right, that's all there is. Pretty straightforward.
I know. I just, like I said, I couldn't rush the survey guy, so.
I get it. I get it. Okay, well, thanks for being here tonight, and good luck.
Okay, thank you.
You bet. Next case. Just one. 22-204-1380 Elk Cam Boulevard. Page 15, thank you. Okay. So you ready to proceed?
Yes, sir.
This has to do with roof and flashing.
My name is Kristen Coulter. I'm employed by the City of Deltona as a code compliance officer. This will be case number DEL 22-204, the City of Deltona versus Rosa Yanat. The property address is 1380 El Cam Boulevard. The parcel ID number is 813-00-938-0020. This is a violation of City of Deltona Ordinance Section 18-5, which adopting the latest edition of the International Property Maintenance Code, Section 304.7, which states that the roof and flashing shall be sound, tight, and not have defects that admit rain. Corrective action for said violation is to repair or replace the roof, gutters, or drainage. The statutory requirements for notification of this hearing have been met by. The notice of hearing and notice of code violation were sent certified mail to the property owner at the address listed with the property appraiser's records. In addition, both notices were posted on the property and at City Hall at least 10 days prior to this hearing. All of the evidence in this case, including the photographs, have been marked as exhibits and submitted to Special Magistrate Clerk. I certify any and all photographs to be true and accurate portrayals of what I observed on the day they were taken. This case was initiated by a previous officer that is no longer with the city. It was initiated on January 30th, 2021. I was given this case on February 27th, 2022, and posted a notice of violation on the same day. Contact was made with the resident on February 28th. I also received a letter from the law firm representing the owner in the claim stating that there was roof damage, and an extension was given. A notice of hearing was posted on July 17th, and the property remains in violation. Contact with the property owner has been made by my supervisor, Supervisor Ron, due to a language barrier.
So the property's in violation still?
It is. The city would like to request 30 days for the property to come into compliance or a fine of $100 per day.
How much was the fine that the city's requesting?
30 days or $100.
Okay, is Rosa Lanat or someone on her behalf present? Ma'am, if you could come forward right to that podium. I think we've got someone that's going to translate. Is that correct? Thanks.
Yes, Ms. Jimenez is going to translate for.
Ma'am, could you tell her that we're here on her property tonight, and it has to do with the roof, and we need for her to tell us, how long is it going to take to get the roof fixed?
Estamos aquí sobre tu propiedad, sobre el techo. A ver cuánto tiempo necesitas para arreglar el techo.
Me lo van a hacer ya.
¿Cuándo?
Ya tengo los papeles aquí.
Josie, can we get her name for the record, please?
¿Tu nombre?
Rosa Llano.
Say it in here. El nombre tuyo, ponlo aquí, dilo aquí.
Mi nombre es Rosa Llano.
Okay. Okay, déjame ver. ¿Cuándo fue que dicen que lo van a hacer?
En esta semana.
Okay. Sir, she's saying that she already got in contact with the construction company and they are already going to start working on the roof within the week.
Cool. Does she ask her if she thinks that she can bring the property in compliance within 30 days?
¿Tú crees que el techo se puede arreglar y todo estar bien dentro de 30 días?
Sí.
Si te damos un mes, lo puedes hacer.
Está bien. Sí.
She says yes.
Finally, if you could just ask her to, for the record, to please state her name and her address, please.
And her address, okay. Dile tu nombre otra vez y tu dirección donde tú vives. Aquí.
Mi nombre es Rosa Llano.
¿Y tu propiedad?
Mi propiedad es la 1380 de la El Cal Boulevard, Deltona, Florida, 32725.
Okay. Would you let her know that What I've heard this evening is that she has worked real hard, and she's going to get the property in compliance within the time frame requested by the city. So I'm going to enter an order giving her 30 days to comply, which is to bring the property in compliance, or a fine of $50 per day. And that's only if, tell her, it's only if the property's not brought in compliance, and if she could let this young lady know, that's important, let this young lady know when she's brought it into compliance. If you could tell her all that.
Sí, él dice que él te va a dar 30 días para que arregles el techo. Después de los 30 días va a ser una multa de $50 diarios si no arreglas el techo con tiempo. Pero dentro de esos 30 días lo tienes que hacer. Y te tienes que mantener en comunicación con la oficial.
Bien.
Porque cuando terminen el techo tienes que hablar con ella para que ellos terminen todo el papeleo y todas las cosas. ¿Está bien?
Bien.
Okay.
Gracias. Thank you.
You're welcome. Thank you for being here.
Okay, gracias por estar aquí.
Thanks. Next case, DL 22-198, 2775 Faison Circle. This is a permit issue. (22-198), 2775 Faison Circle. Officer Suckup, or someone on. Whenever the city's ready.
My name is Taylor Sukup. I'm employed by the City of Deltona as a Code Compliance Officer. This will be case number DEL 22-198, the City of Deltona versus Franco Theresa M. The property address is 2775 Faison Circle, Deltona, Florida, 32738. The parcel ID number is 8130-433-40160. This is a violation of the City of Deltona Code Ordinance, Section 18-3, adopting the latest edition of the Florida Building Code, Section 105.1, which states that any owner or authorized agent who intends to construct, enlarge, alter, repair, remove, demolish, or change the occupancy of a building or structure to install, enlarge, alter, repair, remove, convert any space, any electrical, gas, mechanical, or plumbing system, the installation of which regulated by the code or cause to such work to be done, shall first make an application to the building official and obtain the required permit. The corrective action for said violation is to obtain the permit for the dock. Applications must be submitted to the City of Deltona, 2345 Providence Boulevard, Deltona, Florida, 32725. The structure must meet all the requirements of the city ordinance and be approved on the final inspection. Contact our office with the permit number when obtained. The statutory requirements for the notification of this hearing have been met by the notice of hearing and notice of code violation were sent certified mail to the property owner at the address listed with the property appraiser's records. In addition, both notices were posted on the property at City Hall at least 10 days prior to the hearing. All of the evidence in this case, including the photographs, have been marked as exhibits and submitted to the special magistrate clerk. I certify any and all photographs to be true and accurate portrayals of what I observed on the day they were taken. This case was initiated from a complaint on February 21st of 2022. A notice of violation was posted that same day. Regular contact has been made with the homeowner due to unforeseen circumstances. An extension was given. However, at this time, compliance has not been met. The city would like to request 120 days for the property to come into compliance or a fine of $50 a day to be imposed until such time that the property owner has notified the city of compliance.
Could you put the photos on? We're talking about the dock, right?
Yeah, I'm sorry. I thought I had it on the slideshow.
No, I've been watching the slideshow, but I just want to see the dock, because that's what we're talking about, right?
Uh-huh.
Okay. So if you could leave it there. So what is it that has been done that requires a permit?
So the dock was installed without having a permit, but it's just the addition that was the deck. If I can figure out how to work this, I can. If you see on the property appraisers, that deck was already there. And in this photo, there's an extension right here.
So the permit's for the extension,
Yeah, that extra part.
not
that
for
was
the
added on.
original dock?
Yeah.
Okay, I just want to make sure that's clear for the property owner, exactly what the scope of tonight's about.
Yes.
And it's for the extension. She's nodding her head, so it sounds like she's way ahead of me. So, but I mean, this is the first time I've heard of it, ma'am, so I'm just trying to, like you, I'm just trying to understand exactly what we're talking about here. All right, so so the dock was enlarged, it was extended, and it was done without a permit? Mm-hmm. Okay, and 120 days to comply. And you said there was the reason we're here tonight is because there were some delays, complications, I think you said. Can you tell me what you believe those to be?
Well, I gave an extension before for personal issues. She was running into trouble because the person who built the dock is no longer here, or can.
The extension?
Yeah, that's why the extension was given, because the person who would have been able to draw up the plans for the permit.
No, but I mean,
can't do that.
the extension for the extension.
Yeah.
Yeah.
Oh, you're asking why I'm giving 120 days?
Yeah.
Oh, okay. Pretty much just because it looks like it'll be kind of difficult to undo if it's just her, if she'll have to remove it or get the permit. That's why I gave 120 days,
Okay.
so she has some leeway.
All right. Mrs. Franco? Can you tell me your full name and your address, please?
Yes, Teresa Franco, 2775 Basin Circle, Deltona, Florida, 32738.
So I think I understand what's going on is that you had a nice dock. You know, no good deed goes unpunished. You expanded it, but then I guess you hired a contractor to do it. I couldn't have done it.
It was my ex.
Okay.
Yeah, we did it in I thought it was 2008, but she said it wasn't showing up on the property appraisers.
Needed a
but-
permit. Needed a
Yes.
permit. Didn't get a permit. So she's saying 120 days to comply. What say you?
Well, she's trying to help us out because I keep being undecided. I'm trying to get an architect to draw it, and it's probably too much by trying to get find somebody to draw it up, pay for that, and then it does need some repair, so I'd be willing to do that, of course. But now I'm just kind of flip-flopping. I think I should just probably take it down because it's going to be too costly. I've had a lot of repairs. I've had a new roof. I had to get a tree taken down because my insurance has kind of been a lot of stuff. Taylor's been working with us, but now I think I'm probably leaning more towards just taking the extension.
So what I'm hearing
out.
tonight's hearing is that the city needs you to flip or flop.
I know. Yes.
And they're giving you 120 days.
flop.
They're asking you to flip or flop within 120 days.
I mean, it's kind of sentimental, and I wanted to be able to do it, but I feel like I can't afford it. With the architect
I'm not about here tonight to tell you whether you're flipping or flopping. I'm just. I think 120 days is, quite frankly, is reasonable.
Yes,
so
I do too.
That's what I'm going to find is that, I think the city's being reasonable.
Yes, I do
give
too.
you 120 days to bring the property in compliance, which means getting a permit, or whatever the other option is that you ultimately choose, or a fine of, I'm going to say, $100 per day.
Okay.
So, because I don't see this as being necessarily a big structural or safety issue. But I hate to say it, maybe the better analogy is you're going to fish or cut bait.
Yeah.
Okay?
I do have a question. If I do decide to take it down, do I also need a permit to remove it?
You might need a demolition permit, but I'm going to, that's not,
That's not for
I'm
you.
not the attorney up here.
Okay.
I'm only here to make a ruling on this particular case, and in this case, you need to get a permit or take it down. So if you decide to take it down, then just go to the code enforcement officer, and she'll tell you with whom to speak in the building department to answer that question. My guess is you probably are going to need a demolition permit, but they're a lot easier to get than the permit to construct something.
Right.
Fair enough?
Yes.
Okay.
Yes, sir.
So thanks for being here tonight, and
Thank you.
good luck.
Thank you.
And with your decision.
Thank you. Thanks.
Okay, the next case is 22-181-1098 Lyric Drive. Officer Ron. This has to do with an accessory structure, and apparently, we're not happy with where it's located. So let's hear what the city has to say, and then we'll hear from you folks.
Mr. Reichman, how you doing this evening?
I'm good.
My name is Danny Ron. I'm employed by the City of Deltona as a code compliance supervisor. This will be case number DEL 22181, the City of Deltona versus James A. Sr. and Linda E. Jenkins. Property address is 1098 Lyric Drive. Parcel ID numbers 813040300190. This is a violation of City of Deltona Code Ordinance Section 110-827, paragraph C1D, which states accessory buildings or structures and other than lawn ornaments and fences built in accordance with this chapter shall not be located in the front yard, forward of the edge of the principal dwelling or beyond any side street yard setback on lots of less than 2.45 acres. In this case, it's the pod that's on the property, sir.
Wait, hang on. We're looking at, oh, shoot, can you go back? I just want to make sure what we're all talking about the same thing. It's that storage pod.
Yes, sir.
That's the subject
It
of
should be
tonight's
the next
hearing.
photo coming up.
Right
There it
there.
is. Yes, sir.
Okay, keep going.
Corrective actions, just remove the pod from the location, from the property, will be in compliance. Such requirements for notification of this hearing has been met by the notice of hearing and the notice of code violation was sent certified mail to the property owner at the address listed with property appraiser's record. In addition, both notices were posted at City Hall at least 10 days prior to this hearing. All of the evidence in the case, including the photographs, has been marked as exhibits and submitted to the special magistrate clerk. Sir, this case actually started back last year, March 2021, by an officer that's not here with the city anymore. Just happened to find this case. I got with the zone officer, and we had to address it because it's been such a long time. I've spoken to the residents, the homeowners. They're here this evening, and they actually have a date when they're going to remove this. I still want to put an order just to be on the safe side, 30 days to come into compliance, $50 per day to remove that pod off the property.
Okay. Mr. and Mrs. Jenkins?
Yes.
If you could give me this is just for the record, if you could state your names for the record, please.
James A. Jenkins, Sr.
Linda Jenkins.
Mr. and Mrs. Jenkins, I heard from the city that we've been there a while, but that you've been working closely with the city, which we all appreciate, and that apparently there's an agreement that this little pod's going to get removed. Is that a fair summary?
Yes, sir.
Now, they said that the city says that 30 days is enough time for you all to be able to remove that from your driveway.
Oh, yes.
So that's my next question. Is that something you can do, 30 days?
Oh, yeah.
Yes.
Okay. All right. So it sounds like you all have it worked out, and I appreciate that. That makes my job easier. So I'm going to go ahead and enter an order as requested and agreed to, and it's going to say that the pod needs to be moved 30 days to move it, or a fine of $50 per day. And it doesn't sound like we're going to get to that last part. So I guess the key is just let this gentleman know when you've got it moved, okay?
Yeah. Okay.
Okay. Well, thank you very much for being here and for cooperating so much.
Yeah.
Thank you.
All right.
All right, you be safe.
Thank you, guys. Have a good night.
Okay.
Thank you, sir.
Okay, next case is 22-103 Massey. It's a Massey case, 1800 Snook or Snook Drive, depending on how you pronounce that fish. This is a permit issue. This is the property, 1800 Snook Drive, with Florence, and I apologize, Figurelli. I may have mispronounced it. I apologize. It's the estate. The permit issue. City ready to proceed?
Yes, sir. My name is Marion Laracy. I'm employed by the City of Deltona as Code Compliance Officer. This is a Massey case, number DEL 22-103. City of Deltona versus Figurelli Florence M. Estate. Property address is 1800 Snook Drive. Parcel ID is 813-023-04010, 180. Statutory requirements for notification of this hearing have been met. Notice of hearing and notice of violation have been sent certified mail to the property owner listed with the property appraiser's records. In addition, both notices were posted at the City Hall at least 10 days prior. All evidence in this case, including photographs, have been marked as evidence and exhibits and submitted to the special magistrate clerk. I certify any and all photographs to be true and accurate portrayals of the day that they were taken. It was ruled on April 27, 2022, that the property owner was given 60 days to comply. The owner has not come into compliance within those 60 days and has been receiving a fine of $50 a day since June 27, 2022. As of today, the property has accrued a total fine of $1,500 over 30 days.
How many days?
$1,500.
For how many days?
30 days.
30 days at what per day?
$50.
Have you spoken with the property owner about why we're not?
No, sir, but he is here today. He flagged me down.
Okay, all right. So right now the property's not in compliance. Okay, just for clarity purposes, because it's been a while, what's the violation here, again?
They concreted this driveway without a permit.
It's just a matter of getting a permit then?
Yes, sir.
Okay, all right. Thank you. Anything further from the city?
No, sir.
Okay. Sir, give me your name and address, please.
Yeah, my name is Bill O'Hara. I'm located 1760 South Tyner Court.
What is your relationship to the property, sir?
I'm the husband's, her mother, Florence Figurelli, she passed away.
Okay.
So I guess we live next door, so.
Okay, so do you understand why we're here this evening?
Yeah, I realize now that we've been getting fines, and I had no idea, because this is the first time that I've heard about now, I did hear about, I guess, June 26th, I think was the date. But we go away. I'm retired and I'm never here. In fact, I just came back and I had this thing posted on the garage of 1800 saying that I had an appointment, well, today.
Right.
I had another hearing. So I had no idea about the first hearing. And then, like I said, I'm here for this one. And I had talked to the lawyer, and he had asked if I can get a continuance for the permit. And from what I understand, it needs some type of, I don't know, some type of thing to get tested or something for the weight, I guess.
Yeah, that sounds right. I'm not an engineer, but probably to get the permit. Have you actually gone in and met with someone with the building department yet?
I've been to this place in Deltona probably about 20 times, just trying to get somebody, anybody, to tell me who, I can get to help me.
Tell you what.
And they all say they can't tell you anybody.
Well, I'll tell you what, let me give you an answer to that. See this young lady right here?
Yeah.
She's going to get with you, and she's going to give you the name of the proper people to talk to at the city. Now, the problem from my standpoint is that if we were having this conversation at the first hearing, I could give you a reasonable period of time, or what I conclude to be a reasonable period of time. You've been sitting here, you know how this game works, right? But the problem is we're not here for the first time. This is the second time. And because no one showed up or whatever happened at the first hearing, there was a deadline, and that deadline was not met. And in addition, it's been 30 days since that deadline came and went. So there's a fine that's been accruing. And the purpose of today's hearing is just to quantify that fine. So here's what I'm going to do. I'm going to continue the case, and that means I'm not going to eliminate the fine. I'm going to give you until the next hearing, which is 30 days, to bring the property in compliance. And then I want this case to come back, and we'll figure out what the fine should be at that point in time.
Okay.
So what I'm going to do is, and I'm going to be very blunt here, I'm going to hold this over your head. okay? So I'm going to give you what you're asking for, but I'm not eliminating the fine. It's still there. And if you come back and you're in compliance, because that's what we want, then I'm going to be more inclined to either reduce or waive the fine. We'll see. But if the property's not in compliance at that time, then I'm going to tell you right now, then the fine will, you know, it won't just be the $1,500. It'll be $1,500 plus the additional time. Does that make sense?
I'm saying.
See, but I'm giving you what you asked for, and that is some time, because you're here. So that's only fair, because we're trying to get the property in compliance, okay? Okay.
No problem.
So it'll be, look for the notice. Please coordinate with this young lady right here. She'll help you find out the right people to get this thing fixed, and then coordinate for the hearing so that we can come back next time and everybody can announce that the property's in compliance and we can agree on some sort of reasonable solution. Okay?
Okay, thank you, sir.
Thank you.
Okay. Okay, next case, DL 22039. It's Massey case, 930 Radcliffe Street. Is this one? Yeah, I'm there.
Good evening, sir. My name is Bashir Turkzi. I'm employed by the City of Deltona as a Code Compliance Officer. This will be a Massey case number DEL 22039, the City of Deltona versus Hernandez Nilda and Hernandez Nario. The property address is 930 Radcliffe Street. Parcel ID number is 813030170090. The statutory requirements for notification for this hearing have been met by the notice of hearing and notice of code violation being sent certified mail to the property owner at the address listed with the property appraiser's records. In addition, both notices were posted at City Hall at least 10 days prior to this hearing. All of the evidence in this case, including the photographs, have been marked as exhibits and submitted to the Special Magistrate Clerk. I certify any and all photographs to be true and accurate portrayals of what I observed on the day they were taken. This case was heard on February the 23rd. The property was given 120 days to come into compliance, or a fine of $50 per day until the property comes into compliance. As of today, the property has accrued a total fine of $1,700 over a period of 34 days.
What's the per diem?
Per diem was $50.
Property in compliance at this time?
The property has just come into compliance today due to the property owner having health issues and not finding help. And because of that, the city would like to waive all the fines accrued during the past 34 days.
All right. Ma'am, if you could ask the property owner if he has any objection to the city waiving all fines. I think I know the answer. I hope I know the answer.
Que no hay ninguna multa para hoy. Van a quitarlo todo. Si tú estás bien con eso, no tienen que pagar nada. Okay? See? Yes, he's fine with that.
Could you let him know that the city very much appreciates that he's here this evening and that he's brought the property in compliance?
Queremos decirte sobre la ciudad que gracias por venir hoy y gracias por tener todo tal día y hacer las cosas bien, ¿ok?
Okay. There is no fine.
Que no hay ninguna multa. ¿Ok?
Tell him to take care. Hope he feels better.
Sí, que ya todo terminó ya. No te preocupes.
Gracias.
¿Ok? Ya se pueden ir.
Lo que pasa es que estuvo hospitalizada y 3 veces.
Sí, no te preocupes, que ya...
34.
Ya arreglamos todo.
Sí, sí, ya todo está arreglado, vamos a quitarlo todo de la cuenta, no te preocupes, que ya todo se cierra hoy. Todo se cierra hoy, ninguna multa, no te preocupes. ¿Ok?
Gracias.
Ok.
Thank you very much.
120 days. 120 days.
Thank you, ma'am.
Thank you, sir.
Thank you. Page 9. Okay, we've got 4 cases. All the same address, which is 2849 West Huron. The first one's a Massey case. So we'll go through them in order. 22108. Give me a second to get there, please. Right? Waterfall. Okay, I'm sorry.
Good evening, sir.
22122. Okay, my bad, sorry. This is the case of 22122. It's a Massey case, still a Massey case. And there's 4 cases involving this particular property. Make sure I got that right, 4 cases.
Should be 3 cases,
This
sir.
is Massey case, has to do with debris.
Should be 3 cases, sir. 3 cases for 2849 West Huron, and then for 2864 Jewel, there was a magistrate case, but that's been withdrawn.
No, I think we on,
Okay, let's make sure before we get started.
Waterfall.
I'm on 4 cases involving one property, and that's 741 Waterfall. And that's 22122, 22216, 22190, and 22217. Officer Brokoff? I think I misled you, sir, with the wrong case. That's my bad. We'll blame it on Officer Brokoff.
I've only got 2 cases involving Waterfall this evening. I believe Officer Ron's got a third.
Okay, let's make sure I understand it. I've got 4 folders. Are there 4 cases?
Yes, sir.
Okay. The first one is 22122. There's so many cases, you guys have to split it up, huh? 22122, it's a Massey case. Please proceed. Debris.
My name is Steve Brokoff. I'm employed with the City of Deltona as a code enforcement officer. This will be a Massey case, DEAL 22-122, 737 Waterfall Circle, Deltona 32725. The owner is Barry Kalicki. He was here earlier. This case was heard in May 11th, and he was provided 30 days to come into compliance with his property, or a fine of $30 per day. Myself and Supervisor Ron was on the property this morning, and it has been brought into compliance. But up to date, it was 47 days at $30 a day for a fine of $1,410. However, after conferring with Supervisor Ron and Deputy Director Levitt, we would respectfully request that fine to be waived.
Okay, let me see if I understand this. For the record, this case, DEL 22122, which is a Massey case, has to do with debris. The property is now in compliance.
That's correct.
And notwithstanding that it was brought into compliance past the deadline, and therefore a fine could be entered.
That's correct.
The city is requesting that the fine be waived.
Respectfully.
Okay, so ordered. Is there anyone here for the property that wants to fight that? I didn't think so. Okay. Next case is DEL 22216.
Page 16.
Page 16. Thank you, sir. I really appreciate that. This is not a Massey case, this is a permit issue. 22216, 737 Waterfall Circle. It's a new case.
My name is Danny Ron. I'm employed by the City of Deltona as Code Compliance Supervisor. This would be case number DEL 22216, City of Deltona versus Barry Kalecki. Property address is 737 Waterfall Circle. Property ID number is 813028190010. This is a violation of City of Deltona Code Ordinance Section 18-3, adopting the latest edition of the Florida Building Code Section 105.1, which states that any owner, authorized agent who intends to construct, enlarge, alter, repair, move, demolish, or change the occupancy of a building or structure, or to erect, install, enlarge, alter, repair, remove, convert, replace an electrical, gas, mechanical, or plumbing system, the installation of which is regulated by this code, or to cause any such work to be done, shall first make application with the building official and obtain the required permit. So he installed a fence on his property without a permit. He did apply for a permit a couple of years ago, but the permit expired, so it's like no permit. Such a requirement for notification of the hearing has been met by the notice of hearing. The notice of code violation was sent certified mail to the property owner at the address listed with the property appraiser's record. In addition, both notices were posted at City Hall at least 10 days prior to this hearing. All of the evidence in this case, including the photographs, has been marked as exhibits and submitted to the special magistrate clerk. I certify any and all photographs to be true and accurate portrayal of what observed the day they were taken. Sir, when we were doing research, we were dealing with this gentleman for the last couple of months here, special magistrate. I did the research that when we found the permit was expired, and that's why we're addressing that today. We did make contact with him today. We have an agreement to 90 days.
90?
Yes, sir. And that will give him time because he wants to obtain a variance and for $50 a day after that 90 days, sir.
Is there anyone here for the property on that case?
No, sir, he's not here. He was here earlier.
Okay. So ordered.
Thanks, sir.
Next case is 22190.
Page 13.
This is debris. This is not a Massey case. This is a new case.
No, my name is Steve Barakoff, employed with City of Deltona as a code compliance officer. This is case number DEL 22-190, City of Deltona versus Barry Kalecki and Daniel Kalecki. And the property address is 741 Waterfall Circle. This is a separate lot connected to Mr. Kalecki's, Barry Kalecki's property. And this is violation of debris. This was actually read in last code case, or code meeting, and you gave a continuance of 30 days. Once again, we met with them today. This particular property also is in compliance, and we would like it to be found, though, in non-compliance at the time, in compliance now.
So for a repeat violation next time?
That's correct.
Is anyone here to, on that case? Seeing none, so ordered. Last case on this property is 22217, 741.
Page 17.
Okay. Officer Ron, new case, permit.
Which one is this?
My name is Danny Ron. I am employed by the City of Deltona as a code compliance supervisor. This will be case number DEL 22217, City of Deltona versus Barry and Daniel Kalecki. Property address is 741 Waterfall Circle. It is a vacant lot next to the other property we just showed. The parcel ID number is 813028190020. This is a violation of City of Deltona Code Ordinance Section 18-3, adopting the latest edition of the Florida Building Code Section 105.1, which states that any owner, authorized agent who intends to construct, enlarge, alter, repair, move, demolish, or change the occupancy of a building or structure, or to erect, install, enlarge, alter, repair, remove, convert, or repair any electrical, gas, mechanical, or plumbing system, the installation of which is regulated by this code, or to cause any such work to be done, shall first make application to the building official and obtain the required permit. It's a vacant lot, sir, and he did install a fence there, and there is no permit on file. So to come and corrective action is to obtain a permit for the fence.
So it's still in violation?
Yes, sir. Such requirement to notification of this hearing has been met by the notice of hearing, and the notice of code violation was sent certified mail to the property owner of the address listed with the property appraiser's record. In addition, both notices were posted at City Hall at least 10 days prior to this hearing. All of the evidence in this case, including the photographs, is marked as exhibits and submitted to the special magistrate clerk, and I certify any and all photographs to be true and accurate portrayal of what observed on the day they were taken. Just like my previous case with the no permit, this was also researched and found that there was a fence on the property with no permit. We have agreed with the property owner, Barry Kalecki, to give him 90 days so he can obtain a variance. So we'll give him 90 days, sir, and after that, 50 days fine per day.
$50 per day fine?
Yes, sir.
Okay. Anyone here on that case? Seeing none, so
Same
ordered.
guy, sir. He wasn't here.
Beg your pardon?
He was here earlier.
No, I understand.
Okay.
I understand. Just want to make sure.
Thanks.
Okay, that's that for that case. We've got a couple more faces in the audience, so I'm assuming that we've got those files.
Yes, sir, that would be.
Okay. DL 22-183 and 184. It's 2435 Academy.
Page 11 and page 13.
Page 11. Thank you, sir. Okay, first case is a Massey case. This is regarding debris. Property address at 2435 Academy Avenue. Property owner Karen Black, and I'm going to apologize, Blakicki. I'm probably, or, yeah, I'm sure I mispronounced that, but please proceed, sir. Officer Scott. It's a Massey case.
My name is Jeff Scott. I'm employed by the City of Deltona as a code compliance officer. This will be Massey case DEL 22183, the City of Deltona versus Karen Blakicki. I don't know if I'm pronouncing that right. The property owner address is 2435 Academy Avenue. Parcel ID is 81303-2150060. The statutory requirements for notification of this hearing have been met by the notice of hearing and notice of code violation was certified mail to the property owner address listed with the property appraiser's record. In addition, both notices were posted at the property at least 10 days prior to this hearing. All of the evidence in this case, including photographs, have been marked as exhibits and submitted to the special magistrate clerk. I certify any and all photographs to be true and accurate portrayals of what I observed the day they were taken. It was ruled on June 22nd, 2022, that the property owner was given 7 days to comply. The owner did not come into compliance within those 7 days and has been receiving a fine of $100 a day since June 30th, 2022. As of today, the property has accrued a total fine of $2,700 over 27 days. The city is requesting that the fine continue at $100 per day.
Is property not in compliance still?
No, sir.
Any progress?
So it'd be different type of debris every time I go by there on the driveway.
I'm working on my garage.
Around the property. So it's not the same debris, it's always different debris.
Okay, so the property's still in violation. It's been in violation past the deadline for 27 days, $100 per day. All right, sir, if you could give me your name and address, please.
Jeff Bukiki, 2435 Academy.
Tell me what you want me to hear, sir.
I'm just cleaning out my garage. It's hot.
Okay, well, these are the photos.
Yeah.
Sure looks like it's more than just cleaning out a garage.
Yeah, my garage is a mess. I took
Okay.
everything out to put it all back in.
But we gave you some time to finish that process, and
Yeah, I
I think it was the end of June.
I understand. I've been working on it. It's been really hot out there. I'm trying to work on it at night, be quiet so it's not as hot. It's really,
Well,
really hot.
and I appreciate that. I really do. But I'm in a quite of a quandary here because, in the last case, I felt like I gave you enough time to get the debris cleaned up.
Yeah, I thought 7 days would be enough time too, but
Well, now it's been not just 7 days, but it's been 27 additional days. So what are we looking at? I mean, 7
almost
turned
done.
into 34, so.
it's almost done. The last picture is from today, not that. That's all gone. The one with the lawnmower there, so just mow the lawn. That is not, it's not even that much stuff there. And my son is putting a motor in his vehicle.
Okay, well, here's what I'm going to do. I'm going to reduce the fine to $1,000, but I'm not going to waive it. And the fine's going to continue to run. And the reason I'm going to do it this way, sir, is because this has been going on a while, and I want to create an opportunity for you to be in control of your own destiny, to get this thing cleaned up. So instead of a $2,700 fine, I'm going to reduce it to $1,000 a day, but that fine is going to run at $100 per day until you get it cleaned up. Okay. Next case is 22184. Correct?
Yes, that's on page 13.
Parking. This is a new case. No fine. 22184. Officer Scott.
My name is Jeff Scott. I'm employed by the city of Deltona as a code compliance officer. This will be case number DEL 22184, the city of Deltona versus Karen Blekicki. The property address is 2435 Academy Avenue. Parcel ID number is 81303-2150060. This is a violation of City of Deltona Ordinance Section 6618, subsection E, which states that no vehicles may be parked or stored in the front yard forward of the edge of the principal dwelling except on the approved driveway or driveway extension. Corrective action for said violation is to park all vehicles on approved driveway or driveway extension. The statutory requirements for notification of this hearing have been met by the notice of hearing and notice of code violation were sent certified mail to the property owner at the address listed with the property appraiser's record. In addition, both notices were posted on the property at least 10 days prior to this hearing. All of the evidence in this case, including photographs, have been marked as exhibits and submitted to the special magistrate clerk. I certify any and all photographs to be true and accurate portrayals of what I observed the day they were taken. This case was started as a complaint on March 4, 2022 for vehicles improperly parked in the front yard. Due to the history at this property, I posted a notice of violation and spoke with both the property owner and her son. On June 30th site visit, the property was still in violation. The notice of hearing was posted on the property on July 16th. I also spoke with the property owner regarding this violation. As of today, the property remains in violation. The city would like to request 7 days for the property to come into compliance or a fine of $100 per day to be imposed until such time that the property owner has notified the city of compliance.
Mr. Blakecki, looks like we've got quite a few extra cars there. So the city said that the property's still in violation. They would like for me to enter an order to give you 7 days to comply or a fine to be imposed $100 per day. What do you say about that?
Well, I don't know. The vehicles are parked on the approved thing. It's like,
I'm sorry, I couldn't hear you. Say that again?
the vehicles are parked on approved driveways.
The
Extensions and that.
The extension has to be connected to the driveway. This was explained to him before.
No, it wasn't explained to me before. These are old pictures. It's not like that anymore.
Have you been out there today?
Yes, sir.
Is the property still in non-compliance?
Yes, sir.
How so?
The driveway extension, let me find a photo.
Are all these vehicles operable?
Yeah, they all are. They're all registered and insured and everything.
Okay, I'm going to find that the property remains in violation. I'm going to give you 7 days to comply or $100 per day fine. I'm going to ask you to contact Officer Scott, before the deadline of 7 days so that you can assure him and staff, he can come out and check and make sure that the property's in compliance so a fine will not run. So 7 days, sir.
Yeah. All right.
Okay, thank you very much for being here this evening.
Yep.
Okay, I see a couple more folks here. Probably don't want to be here. Okay.
What was that order again, sir? 7 days?
7 days, what you asked for.
Thank you, sir.
Okay, the first case is DEL 22-108. And this is James Mason, 2849 West Huron Drive. And this has to do with parking.
Mr. Reichman. Myron Semigo, hearing clerk. I have a quick question to sidebar.
Okay. Is the third case, you're saying? There is another case for this. Oh, that's all that matters. Yeah, okay. Yeah, we'll get 3 of them. Okay. Okay, so this first case is, I guess there's 3 cases actually. First one is 22-108. It's a Massey case. This has to do with parking. City ready to proceed. Officer Lopez.
Stand by, sir. In there. You guys can find it. I don't think it's loading in the thing. It's on Marion's USB.
Just
It's,
No, he put it.
I
he
put it on
it
Marion's USB. I use Miriam's USB drive. Switch the ports.
I'm gonna need a shout out for this. Is that his?
Switch the port up, maybe.
That's it. You got it. Nick?
Thank
Mr. Reichman, I haven't been sworn in, sir.
You have not?
No, sir.
You swear or affirm that the testimony you provide tonight will be the truth, the whole truth, and nothing but the truth, so help you God.
I do.
Ready to proceed in this case? This is DEL 22108. It's a Massey case.
Yes, sir. My name is Nicholas Lopez. I am employed by the City of Deltona as a code compliance officer. This will be Massey case number DEL-22-108, the City of Deltona versus Mason James. The property address, 2849 West Huron Drive, Deltona, Florida, 32738. The parcel ID number is 813-032-900010. The statutory requirements for notification of this hearing have been met by the notice of hearing and notice of code violation were sent certified mail to the property owner at the address listed with the property appraiser's records. In addition, both notices were posted at City Hall at least 10 days prior to this hearing. All of the evidence in this case, including the photographs, have been marked as exhibits and submitted to the special magistrate clerk. I certify any and all photographs to be true and accurate portrayals of what I observed on the day they were taken. It was entered into evidence, exhibits proving proper service, and a copy of the original magistrate order, along with photographs. This case was heard on May 11th, 2022. The order was signed on May 11th, 2022, giving 2 days to come into compliance or a fine of $50 per day until the property comes into compliance. On May 14th, 2022, the homeowner was found in violation with multiple vehicles located on the right side of the property. And on May 26th, 2022, the homeowner was observed in compliance with the case being considered closed resolved. During that time, the homeowner was only considered 12 days in violation. However, the case was reopened on June 3rd, 2022, while visiting the property to post a notice of Massey hearing. The resident was observed in violation again with at least 3 vehicles on the right side of the property, and has come into compliance as of today, July 27, 2022. The property is now 66 days in violation. The property has been in violation from May 14, 2022 to May 26, 2022, 12 days, in addition to the case being reopened on June 3, 2022 to the current date of July 27, 2022. A total of 66 days at $50 a day for a total fine of $3,300. Based on the testimony and evidence submitted in this case, the city is requesting that the magistrate impose the following. Massey motion, property in compliance.
Okay. Let's sort that out. Property is in compliance right now.
Yes, sir.
Your testimony is that notwithstanding that the property is now in compliance, it had been failed to meet the prior deadline of the prior order. So for a total of 66 days at $50 per day, $3,300.
Yes, sir.
I have not heard the city's recommendation as far as the amount of the fine.
We suggest that can you repeat your question? I'm sorry.
Is the city looking for for the special magistrate to impose a fine, and if so, how much?
We're looking at a fine of $3,300 be imposed for the days that he was in violation.
That's what you're asking for the Massey order to state?
Yes, sir.
Okay, no reduction?
No, sir.
Okay. All right. Mr. Mason?
I need to be sworn in, please.
Okay. Thank you for, do you swear or affirm that the testimony you provide tonight will be the truth, the whole truth, and nothing but the truth?
Yes, sir.
Could you give your name and address, please, sir?
James Mason, 2849 West Huron Drive.
Okay, this case is coming back for the second time, Mr. Mason. You've been sitting here, listening to all this stuff, and so I probably have learned a little bit about it. This is what's called a Massey hearing, and it follows up from an earlier hearing. Were you at the earlier hearing?
Earlier today?
No. When this case came before me were you here?
I was, yes.
You were?
Yes, sir.
Okay. Well, in that case, I gave you a period of time to come in compliance. And they're saying that you didn't come in compliance for extended period of time, and therefore the fine is to be imposed. And they're saying that the city's saying the property is now in compliance, but is asking me to enter an order to fine you, to quantify the fine of $3,300. So this is your opportunity to tell me why you think I shouldn't do that.
Well, I guess I'm really confused now because, well, I was in compliance within the time frame. So you can't even drive on that side? Like you can't? What's the point of having a gate?
The way this case was, you can't park vehicles on your side of your property.
To pick my trailer up or to load it up? I don't.
And that's the question for him, but I mean, my understanding is you can't park any vehicles on the side of your property in the city of Deltona. Is that correct?
The original violation was for more than 2 vehicles on the side or rear yards.
More than 2.
Yes,
I apologize. More than 2. That was the violation.
Because I had 3 boats, and I got rid of one of them. Those were parked back there. But the vehicles don't stay, they're not parked there. If you see the truck on the side, it always has the trailers because I'm trying to load the stuff up. And then the other part where I'm really confused is, I don't see him very often. He comes, and if I try to talk to him, he leaves right away. He won't stay. But he did stop by a couple Saturdays ago, and I had the truck in the backyard. I had it back there hooked to the trailer. And I asked him, I said, you want me to move the truck? Because he said he was going to take some pictures. I said, you want me to pull the truck forward? Because I had just brought it back there. And he said no, that the case was closed. I said, okay. I said, thank you, like always. And the next thing I know, like a week later, I got a violation. He violates me again for vehicles parked on the side. So they don't stay there. I don't understand. I guess I'm confused. Because like today, he said I'm in compliance today, but I wasn't when he came by. I mean, I was parked on that side of the grass, and then. So where does the violation?
What I'm worried about is making sure that my prior order is complied with. And my prior order said that the code that's being violated right now is that there's more than 2 vehicles parked in your side yard. So whenever that occurs, that's a violation. And its amount of $50 per day. So, the city has testified that, in their opinion, there's been 66 days where that's occurred at $50 per day. And what I need for you to tell me is why you think that's not the case.
Well, because it could have been no more than like 2 weeks ago. When he came by, he said the case was closed. And then I guess it was a week after that, so it must have been about 3 weeks ago. He said it was closed, and then when he came by, I don't know. I guess he came by the week after.
Okay, I'm going to approach this from a different angle.
Yeah.
Officer Lopez.
Yes, sir.
My original order said that it can't be more than 2 vehicles in the side yard.
Yes, sir.
And gave him 2 days to comply. After that 2 days, did you inspect the property?
Yes, sir.
Was it in compliance?
No, sir.
Why not?
He had multiple vehicles on the property still.
Okay. What kind of vehicles back then on that 3rd day, or after the deadline passed for my order? What are we looking at? What kind of vehicles were out there?
Stand by, sir. So we're looking at 2 boats, trailer. Of course, it was obscured by the fence that he installed without a permit, but...
That's a different issue.
There's a vehicle, that was on the 11th.
We're talking about when you went out after the deadline, that first missed deadline. I'm trying to calculate the number of days here, because you said 66, and he's not comfortable with that. So we're gonna go back and we're gonna break this down.
It is hard to make out on the picture, but he had 3 vehicles on the property the 14th.
Mr. Reichman, Richard Lovett, I'd feel more comfortable if we had just went ahead and said no fine on this one at this time and gave him a credit for that. This way, if it does happen again, though, he would come back as a repeat and the
Yeah,
fine
I'm
would
not
start then.
I'm not trying to prevent there to be a fine. It's just that I've got to have a record that's supportable if I'm going to impose a fine.
Yeah, I agree, and I don't see any pictures in here that kind of help with this at that point. That's why I'd feel more comfortable with it.
Okay, so property's in compliance now. So, Mr. Mason, the city's recommending there's going to be no fine. But let me tell you, if the property, on this issue, on this violation happens again, and that's more than 2 vehicles in your side yard, it's going to be considered what's considered a repeat violation.
Okay.
So there's no tolerance. That means that for each day from this point forward, for each day, you don't get notice. You just start running a fine. So that means if someone comes out from the city of Deltona and sees in your side yard you've got more than 2 vehicles, that's violating the same code. It's called a repeat violation. And I'm going to say it. I've said it a million times. I'm saying it again. The purpose of tonight, purpose of all of these meetings, is not to take money out of your pocket. The purpose of these meetings is to get the property in compliance. And that's what I'm focused on. And that's the message that I'm hoping you're hearing from me, sir. So when the city says no fine, I don't have a problem with that. But I just want you to understand that if it comes back and you've got, because it sounds like it's a little, I'm going to be candid with you. It sounds like it's a little bit of a moving target over there on your property.
Yeah.
That's what I'm hearing.
Is the backyard and the side yard the same? So like once because originally it was in the backyard, I had too many boats, so I got rid of the big one.
So what I want you to do is I want you to coordinate with the code enforcement officer about what this code requires so there's no misunderstanding, Mr. Mason.
Okay.
Okay? But I just want you to know, again, I'm not trying to scare you or anything or threaten you, but right now we're done. But if it comes back, it's going to be a fine. You understand what I'm saying?
I understand what you're saying, but what I don't understand is, so if I was to, say, pressure wash the driveway, I have to have the cars on the driveway while I pressure wash it?
Again, there's a bunch of scenarios out there, and it's not really the right time or the right place for me to kind of go through there, all the different things that could happen out there.
Yeah.
But this gentleman right here is an expert in the application of the
but
city
I can't get a
code.
hold of him. He won't talk to me. I don't know why.
Well, someone's going to talk with you. I can guarantee you that.
Okay.
Someone from the city is going to answer your questions.
Okay.
Okay?
Yep.
If not tonight, then sometime, hopefully tonight.
Okay.
So that's the disposition of this case. Okay, we've got another couple cases, so.
All right, I understand.
The next case is DEL 22131. And this is on, this is a new case. It's a permit case. 131, I've got it. Yep. Officer Lopez, you ready to go?
Stand by, sir.
Yes, sir.
My name is Nicholas Lopez. I'm employed by the City of Deltona as a code compliance officer. This will be Massey case number DEL-22-131, the City of Deltona versus Mason James. The property address, 2849 West Huron Drive, Deltona, Florida, 32738. The parcel ID number is 813-032-900010. The statutory requirements of notification of this hearing have been met by the notice of hearing and notice of code violation were sent certified mail to the property owner at the address listed with the property appraiser's records. In addition, both notices were posted at City Hall at least 10 days prior to this hearing. All of the evidence in this case, including the photographs, have been marked as exhibits and submitted to the special magistrate clerk. I certify any and all photographs to be true and accurate portrayals of what I observed on the day they were taken. It was entered into evidence, exhibits proving proper service, and a copy of the original magistrate order, along with photographs. This case was heard on May 11th, 2022. The order was signed on May 11th, 2022, giving 14 days to come into compliance or a fine of $50 per day until the property comes into compliance. The property has been found 9 days in violation. The property has been in violation from May 26, 2022 to the date of June 3rd, 2022. A total of 9 days at $50 a day for a total fine of $450. Based on the testimony and evidence submitted in this case, the city is requesting that the magistrate impose the following. a $450 fine against Mr. James, and the property non-compliance.
Is the property in compliance at this time?
Yes, sir.
But he missed the deadline by 9 days,
Yes, sir.
$50 per day. All right.
Yes, sir.
All right, Mr. Mason, do you understand what the city's asking?
Yes, but I thought you just said it was a new case.
I was mistaken. This is a Massey case.
Because this one was closed, and then the same day that he violated me again for the cars on the side, I got a building permit violation again, which was like about a couple weeks ago. But we even called, or I called down to the city and tried to find out what it was for, and no one could tell me. But I was in compliance with the fence. As soon as we left here, the very first time I came, I was on Wednesday. That Friday, I had lost my job, so I was not able to get the permit. So I was trying to get a hold of somebody, make sure if I just took it down, would that be okay? And I did miss it by 1 day. I did miss the 1 day, and I called him that Friday, because I think I had 7 days or 2 weeks, whatever it was. And I called on Thursday. I should have had it done by Wednesday, to make sure it was okay if I pulled the fence down, and the woman I talked to said it would be okay. So I just took it down, but.
All right, so let's see if I understand this. There's a couple ways for the property to come in compliance. One was get a permit, and the other is take the fence down. What happened? Was the fence taken down?
He took the fence down, yes, sir.
And that's why it's in compliance?
Yes, sir.
He's saying you got it done within one day late.
No, sir.
Okay, what was the date of compliance?
The date of compliance was May 26th.
Do you have a picture of the date of compliance, which would have been 9 days after that?
I was able to inspect the property May 27th due to exigent circumstances, but the fence was still observed on the property, and he did not notify the city that it was taken down.
Okay, fair enough, but he's saying he took it down 1 day late. Are you saying that he did not take it down 1 day late?
Yes, sir, he did not take the fence down.
How do you know that?
He did notify the city.
Okay, so you're saying he didn't notify the city for 9 days, but he might have taken it down. He might have been in compliance, just failed to notify you.
Yes, sir.
Okay.
But I did call the city. I asked, before I took it down, I asked to make sure that was going to be okay. And I even left a voicemail on Lopez's machine.
You were late in taking it down.
Yeah, I was, a day.
Okay. All right, I'm going to find that the property is now in compliance, but it did not meet the deadline, and I'm going to impose a fine of $150. Okay?
But the only reason why I was the 1 day is because I was hoping to see Lopez when he came by to ask him if it would have been okay to take it down. I didn't want to just take it down and then him not know what I was doing, because I said I was going to get a permit, but then because I lost my job, I couldn't afford it.
I understand that. I understand that. So I'm not going to, the city was looking for a fine of $450. I'm going to reduce it to $150.
And I'm still,
because it was late.
And I'm still not working.
Okay?
All right.
All right, so we've got one more case, sir. This is DEL 22-128. And let's see, this is Officer Lopez, and this is a Massey case, 22-128. I do not believe that it is on an agenda.
Yes, sir.
So, and this has to do with, give me a second, storage of properties, outdoor storage, correct?
Yes, sir.
Okay. City ready to proceed?
Stand by, sir. My name is Nicholas Lopez. I'm employed by the City of Deltona as a co-compliance officer. This will be Massey case number DEL-22-128, the City of Deltona versus Mason James. The property address, 2849 West Huron Drive, Deltona, Florida, 32738. The parcel ID number is 813-032-900010. The statutory requirements for notification of this hearing have been met by The notice of hearing and notice of code violation were sent certified mail to the property owner at the address listed with the property appraiser's records. In addition, both notices were posted at City Hall at least 10 days prior to this hearing. All of the evidence in this case, including the photographs, have been marked as exhibits and submitted to the special magistrate clerk. I certify any and all photographs to be true and accurate portrayals of what I observed on the day they were taken. It was entered into evidence, exhibits proving proper service, and a copy of the original magistrate order along with photographs. This case was heard on May 11th, 2022. The order was signed on May 11th, 2022, giving 30 days to come into compliance or a fine of $100 per day until the property comes into compliance. The property is now 46 days in violation, with outdoor storage still being observed on the driveway and side yard areas. The property has been in violation since June 12, 2022 to the date of July 27, 2022. A total of 46 days at $100 a day for a total fine of $4,600. Based on the testimony and the evidence submitted in this case, the city is requesting that the magistrate impose the following: mass motion still in violation, and the fine to continue until the property is in compliance.
Okay, I need to see a photo or photos of the condition of the property today, if you have them.
This is the condition of the property today. Excuse me.
Okay, there's about 15 different photos, so I just need for you to tell me which photos are the ones of today.
This is a photograph of today. You can see on the driveway, the outdoor storage, and on the side yard area on the right.
Okay, I got it.
There's another photograph.
All right. You know, of all the ones that I've heard tonight, Mr. Mason, in your case, this one probably gives me more concern than anything else. I mean,
yes, sir. The driveway's completely clean now since he left, but I am in violation. I didn't get this one.
So I mean, look, again, I'm not here to try to break you with financial fines, but we need to get this property in compliance.
From the fence forward, it's clean right now. There's not one from the fence forward right now. There's nothing in the yard.
So that's a good point. So if is that enough, Officer Lopez?
I have a picture to prove it too. A couple of them.
Mr. Reichman, I can answer that. The whole property has to be clean. It cannot be behind the fence either.
Yeah, I'm not denying that I.
Okay.
Am not
So because the city would be moving forward from this point with doing an abatement, and we would abate the backyard at that time.
Okay.
So let's say where we are right now. I'm going to, for me, I always try to put it just so I understand it. Generally speaking, that's when everybody understands it. So there was a prior order told you to remove all this, and it gave a deadline.
Yes, sir.
Didn't meet that deadline. We all understand that. There's the photos. So the deadline was blown by 46 days at $100 today, so I could impose a fine of $4,600, and that fine's running at $100 today.
Yes, sir.
Now, what the gentleman from the city just said is that the next thing that they can do is they'll come out and they'll clean it up.
Yeah.
And there's a process that they have to follow. And it'll cost the city of Deltona taxpayers some money. And they're going to then impose that upon on your title. That'll be on like it'll add it to your tax bill. It's called nuisance abatement. I don't have anything to do with that. But I'm just giving you a heads up so you understand that's what this gentleman's saying. So that's it. If you can't get this cleaned up, that's your future.
Yes, sir.
So tonight, I've got to figure out whether to fine you $4,600 because the property's still a mess. So what I'm going to do is I'm going to impose a fine of $2,500 because this has been going on a long time. And I would encourage you to just try to, if you get family, friends, your church, whatever, get out there and try to get this fixed because this fine's running.
Yes, sir.
And then it's going to be cleaned up by the city and it's going to cost you even more money. Again, I'm going to say it again. What we're interested in is getting the property in compliance for yourself, for your family, for your neighbors, for the community. Is that fair?
Yes, sir.
Okay, so that's my order. Fines are going to be reduced to $2,500. It's running at $100 per day, and you heard the city what they might do with nuisance abatement. All right.
Yes, sir.
So thanks for being here today. Good luck.
Thank you.
Okay. Okay, see some patient, long-suffering folks in the back. What case is that?
It's going to be case 21-138. It'll be the last case on the agenda, sir.
22-133? 138. Okay, that's a reduction of fine.
No, I got this. I do these. No?
That's fine, I got it. Nope. Is that it? That's the phone? Okay. That's a nice thick one. All right, city ready to proceed?
City's ready. I'll just let Ms. Acevedo go with her reasoning on why she would request this hearing for reduction of fine.
What's the fine right now?
So the fine that she's asking for reduction on is for $16,000.
Even?
16,000 even.
Is property in compliance?
Property is in compliance, and that's where the fine stopped.
How long has the property been in compliance?
Property was brought in on May 5th, 2022.
Okay, so it ran for a long time to get 16,000. How many days are we talking about?
This case, October 27, 2021, they were given 30 days to bring it into compliance, and it went for 152 days, and then on that one, it went for 160 days.
Okay.
There was 3 cases total that went for that.
So it's three cases, that's how you get to the 16,000?
No, she's only asking for reduction on the one. The other 2, you've already given her a reduction on,
Okay.
on those 2 cases.
But on this case, it's 16,000.
On the case for the 16,000, which was for the roof.
Okay, and it was a TARP situation? What was it?
So the case was brought to us by one of the tenants on September 24, 2021, who claimed that the roof had been leaking for months. According to paperwork Ms. Acevedo provided us, the damage on the building which caused the water damage was done by Hurricane Irma on 9/10/2017, and then she had another water damage on 2/28/2020. So this water damage was for 3 years before the city was made aware of it. Or I'm sorry, 4 years before the city was made aware of it.
Fair enough. All right, Mrs. Acevedo, am I pronouncing that correctly?
Yes, sir.
What are you asking me to do today?
To see if we can eliminate the debt.
You want it just eliminated?
Yes, sir.
Okay, tell me why I should do that for a $16,000 fine that was running because this property was not in compliance for a long period of time.
I had before, well, let me start first. My name is Janet Acevedo, and I live in 161 Hummingbird. Before the tenant, that tenant's been having issues with me, I don't know why, from the beginning, and he just started complaining. I've always been on top of my things. Before that, I had lawyers that have been fighting because the insurance didn't want to pay. I had other roofers before that trying to, patch here and patch there to maintain the property. Up to they decided, the insurance company, to release the funds and fix the roofing at this point. But I always try to, call people and say, hey, to get up there and patch what's happening up there.
What's the city's position about the request from the property owner in this case?
I'm sorry?
What's the city's position on her request?
The city would like to stand with the fine of $16,000. The reasoning is this was damage that was done, and the tenants were living with this damage for 4 years. This is not a single, this is a quadplex. You have 4 rentals in that.
Yes,
so
sir.
you had 4 tenants for 4 years in that area. And the court case that she actually opened for her loss wasn't open until October 14, 2021. So I don't feel that there's any reason to give her a reduction in this fine.
This property is not homesteaded, is it?
No, it's not.
So you could foreclose on the lien.
Correct.
Okay, this is a tough one. I mean, this one's not a good set of facts, Ms. Acevedo.
Sir, let me go ahead and explain a little bit more further in details. The tenant that accused there, he destroyed my property completely. Completely at this point. There's, I mean, from everything that you can imagine. He owed me money. I tried to work with him, making a payment plan. He decided not to. So he took me to court. I've sent all the proof showing everything that I was doing at that time. The judge says it's up to her if she leaves you there or not. I told him that I'll give him 2 or 3 weeks. And I shouldn't have done that, which I did, and that's when I had my property completely destroyed. I mean, at this point, I mean, I've always been on top of things. I used to live there, next to apartment A, apartment B. I've been out of that apartment 11 months already. So, because I live someplace else now, but I used to live there for 11 years.
All right, here's what I'm going to do. I'm going to use the biblical example of Solomon, and I'm going to cut this baby in half, and I'm going to reduce the fine to $8,000, but I cannot just waive it, ma'am, because of the extensive history of this case. So I'm going to reduce the fine to $8,000. That's my ruling. So you've accomplished a lot, but you've not accomplished everything. Thank you. Thank you for being here.
Thank you. Have a good night.
You too, ma'am. Okay. I do not see, are there any other cases? Ma'am, are those folks with you? They're all together. All right, so we have no more cases where people are here. Correct. Okay, so we're going to go back to where we left off in the agenda. Okay. Oh, okay. All right. What? 18. Okay, we've got a special request. 22-106 and 22-196. Okay, we'll do page 14 first. Okay, 22-196. This is a new case. It's a permit. Property is Frederick Siu. The name's familiar. 870 Maybrook Drive, Officer Ron. It's a new case. Permit.
196. All right, sir, I'm ready. My name is Danny Ron. I am employed by the City of Deltona as a code compliance supervisor. This will be case number DEL 22196. City of Deltona versus Frederick J. Siu. The property address is 870 Maybrook. Parcel ID number is 813066140050. This will be a violation of City of Deltona Code on Section 18-3, adopting the latest edition of the Florida Building Code Section 105.1, which states that any owner, authorized agent who intends to construct, enlarge, alter, repair, move, demolish, or change the occupancy of a building or structure, or to erect, install, enlarge, alter, repair, remove, convert, or replace any electrical, gas, mechanical, or plumbing system, the installation of which is regulated by this code, or to cause any such work to be done, shall first make application to the building official and obtain the required permit. Sir, in this case, there was a fence that was put up and no permit has been applied for. Such a requirement for notification of hearing has been met by the notice of hearing, and the notice of code violation was sent certified mail to the property owner at the address listed with the property appraiser's record. In addition, both notices were posted at City Hall at least 10 days prior to this hearing. All of the evidence in the case, including the photographs, is marked as exhibits and submitted to the special magistrate clerk. I certify any and all photographs to be true and accurate portrayal of what I observed on the day they were taken. Sir, this, myself and Officer Bashir, during training, we were doing proactive code enforcement in the area. It started off with improper parking of the trailer. And when I did the research for that, I saw that there was, compared to an old photo, that there was no fence was installed without a permit. This was actually started on March 30th, 2022, and since then we've done the procedures to bring it to the special magistrate. The city would like to request 30 days for the property to come into compliance or a fine of $100 per day to be imposed at such time that the property owner has notified the city of compliance.
So the property is not in compliance at this time?
That is correct, sir.
City is requesting the property be brought in compliance within 30 days?
Yes, sir. Gives them time to come pull a permit or remove the fence.
Okay. Or a fine of how much per day?
It will be $100 per day. Sir, in this particular case, I just want to put it on record. We were going to present it back in April. He notified us just day before that he needed accommodations for his disabilities. So we backed off. We also posted a letter from the actual assistant director for the department, which I have a copy of, and still, I think he sent an email today trying to request accommodation, and that's.
You have the email from that I gave you for today?
No, I don't have the email.
Yeah, that's pretty important that you bring that up to me. This is a case, I think, where he's filed a complaint.
Yeah. Mr. Reichman, this, the gentleman involved here asked for the city manager for continuance today. He did in this case receive a letter from Richard where we have basically asked, what is your disability, for medical information documenting that, and what accommodation are you requesting? And we continue to not get those questions answered. The city manager denied his request for continuance.
Well, that would be actually my job to either grant the continuance or not. So what I'm hearing the city say is that indirectly there was a request for a continuance submitted for tonight's hearing, on this case, 22-196, on the grounds that he received an accommodation.
We got that same request in the April hearing too. That's why we continued it, and that's why we sent that letter out and given them that time limit to get us that information so we could give him the accommodations that he needed. And he failed to do that, and then today he sent an email saying I can't do it.
Okay, do you have a copy of that email?
Dan, if you don't, I can go get it off my computer.
Can you?
I can go get that.
Okay, let's just dive a little deeper here. So this case is actually a case that was continued. This same case was continued from April. Hang on, don't need to leave, officer. So this case was continued from April. Is that correct?
Okay, we never presented it. You never heard it. We just decided to.
Okay, this never got to a hearing.
No, sir.
This is the first time this permit matter has come before me, but it was originally scheduled to go in April.
That is correct, sir.
He asked for an accommodation.
Back then, the day prior, which we could not accommodate at a time because of the short notice.
Okay.
And now.
So what's the status of that request for that accommodation at this point?
The request was made, but we never got any backup paperwork to add to it on what we needed to provide.
Okay. So my only other question would be, what is the city attorney's position with regard to proceeding with this case, given the pending complaint before the federal administrative agency?
There is a lawyer for the city who's handling his complaint of discrimination with HUD. I discussed the matter with him. He did not see any reason to delay any of this. And, you know, I mean, again, we can't get the information that we need to be able, there's no resistance on the city's part in trying to provide accommodation if we could determine what that is under the law, and we can't get that answer.
Now, the accommodation, if I remember correctly, in some of the earlier cases, was there was a vehicle that was parked in his driveway.
Yes.
This is a very different case. This is about a permit.
That's
He was
correct.
saying that he needed that vehicle to, that was his accommodation.
That'll be the
Needed-
second case you're going to hear, sir.
I can't hear you, sir.
That is going to be the second case you're going to hear this evening.
Okay, all right, but this case right now is a new case, and we don't know what, as we sit here today, we don't know what his disability is, correct?
That's correct.
Okay.
But I will tell
Did you
you,
make a request to testify this evening, for us to call him or anything?
no.
And he's been offered the opportunity to provide some additional information?
Yes.
Okay. All right, I'm going to proceed and enter the order that the property is in non-compliance, 30 days to comply, or a fine $100 per day.
Thank you, sir.
And that's that case. The next case is 22196, I believe. No, 22106. Okay. This is 22106. It's a repeat violation? Please proceed.
This is going to be a repeat violation, correct, sir? Is it okay to proceed, sir?
Yeah, go ahead.
My name is Danny Ron. I am employed by the City of Deltona as a code compliance supervisor. This will be case number DEL 22-106. It's a repeat case of DEL 19-029. City of Deltona versus Frederick J. Sue. Property address is 870 Maybrook. Property ID number is 813066140050. This will be a violation of City of Deltona Code Ordinance Section 66-19-3, which states that boats, trailer, recreational vehicles should not be parked or stored either within the public right-of-way or within the portion of the lot line across the full width of the lot between the front lot line and frontmost part of the principal structure. Corrective action is to park the trailer behind the front face of the house or remove from the property. Statutory requirement for notification of hearing has been met by the notice of hearing and the notice of code violation was sent certified mail to the property owner at the address listed with property appraiser's record. In addition, both notices were posted at City Hall at least 10 days prior to this hearing. All of the evidence in this case, including photographs, has been marked as exhibits and submitted to the special magistrate clerk. I certify any and all photographs to be true and accurate portrayal of what observed the days they were taken. Sir, this case started March 28. We observed the violation for 3 days.
Is the violation that trailer right there?
That is correct, sir. It's
Okay,
parked in
thank
front of the house.
Sorry.
So on March 30, that's when I noticed them. And that's the day I would like to start the fine as a repeat offender.
So wait a minute now. So this property has had an order, a code enforcement violation order previously.
Yes, that is correct.
Within
And that'll
5
be,
years, same violation.
that is correct. And Exhibit H is the copy of the order for DL 19-029.
And it was brought into compliance.
Yes, it was brought in compliance.
So simply put, in the past, this guy had that trailer on his property that's a violation of the code. He's brought to code enforcement. He brought it into compliance, and there was not a fine.
It was brought in compliance with a fine.
With a fine.
Correct.
Okay, but then it was brought into compliance.
Yes.
Now it's not in compliance again, so it's a repeat violation.
Yes, sir.
Okay.
And we did adjust, I think we tried to do a couple of months ago, a special measure case, and we did put the verbiage in the notice of hearing about the repeat offender in there.
Okay, so how long has this property been in repeat violation?
Since March 30th.
Okay, how many days is that? Still in is it still out there?
It's still in violation, sir.
So what's the city looking for as far as, what's the number of days? In other words, there's a quantity of time that the repeat violation has occurred.
Correct.
So what is that time frame?
Okay, I got from March 30th to here, it's 117 days.
So since March 30th, okay, we can do the count. Since March 30th through today.
I'm estimating there, sir.
I
Sorry.
understand. That's why I don't want to do that. So it's from March 30th, inclusive of March 30th.
It's 119 days.
119 days. Thank you.
Thank you.
Still running. And what's the per diem fine the city's looking for?
$100 per day, sir.
How much?
$100.
Okay, I'm going to make it at $50 per day. Okay, so let's talk about, so far everything's fine at $50 per day. Let's talk about this now. Has the city received a request from this gentleman for a continuance of this case as well?
Yes, it was the same.
And the grounds for that request for the continuance are?
That he couldn't make it because he needed accommodations.
Okay, so let's be very clear. Is the accommodation that he can't make it tonight, or is the accommodation that he needs that trailer?
He said he couldn't make it here tonight because he needed accommodations, but we still have not received anything to be able to give him accommodations that he requires.
So yesterday, he asked for a continuance because he needed accommodations, but he didn't specify why.
He sent it this morning.
This morning?
This morning.
He sent an email saying that he wanted a continuance because he needed an accommodation.
Yep.
But he did not specify the nature of the accommodation.
No.
Did the city respond to say, please let us know what you need?
Yes, sir.
That's why we had sent that letter giving them till the week before, so that way the city had adequate time to give them.
That's July 7th. Today's July 27th.
Yep.
So today, we received a request for a continuance, saying there was a request for accommodation. And you told me that you responded. How did you respond to him on July 27th, not this letter?
The city manager responded to him, that we had given him time to come in there and provide the
This morning, the city
information.
manager did this. And how did he do that?
There was done in an email.
Email.
Okay. I would like those to be made part of this record.
Do you have a copy of it, Richard?
Yeah.
So for the record, the email received this morning from Mr. CEO requesting continuance, and the city's manager's response to that also today are going to be made part of this record. Okay? He is not requested to appear by phone or for any other specific thing that we can do to help him out. It was just this, I need an accommodation, I need a continuance. That's all he said. And again, the city has spoken to its, I guess, attorney handling this matter, and the attorney said that there is no problem with proceeding with today's hearing. Is that correct?
That's correct.
Okay. I'm going to enter the order that the property remains in violation. It's a repeat violation since March 30th, which is 119 days, and it's still running at $50 per day. Has anyone done the math to figure out what that fine is? 119 times 50.
That's $5,950, sir.
Yeah, that's pretty straightforward math. Okay, that's my order.
Thank you, sir.
Thank you. Okay, let's get back and are there any others before we jump back and try to finish this evening's fun?
Give me one. Yeah.
Okay, then we're going to go back to 22-133, Officer Laracy. This is a Massey case. 1609 Gregory.
Thank you, Marcia.
Debris. I'm there.
My name is Marion Laracy. I'm employed by the City of Deltona as a code compliance officer. This is in reference to a Massey case, number DL 22-133, the City of Deltona versus Watahovich, John M. and Carol M. Billings. Property address is 1609 Gregory Drive. Parcel ID is 813-031-060-020. Statutory requirements for notification of this hearing have been met by notice of hearing, notice of violation sent certified mail to the property owner with the, at the address listed with property appraiser's records. In addition, both notices were posted at City Hall at least 10 days prior to this hearing. All evidence in this case, including photographs, have been marked as exhibits and submitted to the special magistrate clerk. I certify any and all photographs to be true and accurate portrayals of what I observed the day they were taken. It was ruled on May 11th that the property owner was given 60 days to comply. The owner did not come into compliance within those 60 days and has been receiving a fine of $25 a day since July 11th. As of today, the property has accrued a total fine of $400 over 16 days. City is requesting that fines continue at $25 per day until compliance has been met.
Property still in violation.
Yes, sir.
Has been in violation for 16.
Yes, sir.
1-6. $25 a day at $400 fine to continue to run.
Yes, sir.
So ordered.
Thank you, sir.
Next case is 22144. This is Officer Muse. This is also debris. Yeah. Yeah, I'm going right down them now.
Okay. Okay, my name's Dennis Muse. I'm employed by the City of Deltona as a code compliance officer. My credentials are on file. This is a Massey case number DEL 22144, City of Deltona versus Cole, FD Portfolio 3 LLC, Family Dollar Stores Incorporated. The property address is 2901 Hallam Boulevard, Deltona, Florida 32738. Parcel ID number is 813039130080. The statutory requirements for notification of this hearing have been met by the notice of hearing and notice of code violation sent certified mail to the property owner at the address listed with the property appraiser's records. In addition, both notices were posted at City Hall at least 10 days prior to the hearing. All the evidence in this case, including photographs, have been marked as exhibits and submitted to the special magistrate clerk. I certify any and all photographs to be true and accurate portrayals of what I observed on the day they were taken. It was ruled on May 25th that the property owner was given 14 days to come to compliance. The owner did not come into compliance within those 14 days and has been receiving a fine of $50 a day since June 8th of this year. As of today, the property has accrued a total fine of $1,750 over 35 days. As of today, or as of the 13th, when the fine stopped, I did check the property, and this is the pictures now, that what they're showing, that it's been cleaned up, and it's a whole lot better than it was.
This property is in compliance, but failed to meet the deadline set forth in the prior order, so a fine for 35 days at $50 per day, $1,750.
Yes, sir.
Any communications with the property owner?
Just with just the manager of the store, who seems to be a little bit more proactive in getting things cleaned up.
Okay, so ordered.
All right, thank you, sir.
Thank you. Okay, next case is 22166. Another Massey case, accessory structures.
My name is Taylor Sukup. I'm employed by the City of Deltona as a Code Compliance Officer. This will be case number DEL 22-166. The City of Deltona versus Driggers Jennifer Key. The property address is 178 Rosedale Drive, Deltona, Florida 32738. The parcel ID is 813059400310. The statutory requirements for this notification of this hearing have been met by the notice of hearing and notice of code violation sent to the certified mail and property owner at the address listed with the property appraiser's records. In addition, both notices were posted at City Hall at least 10 days prior to this hearing. All the evidence in this case, including the photographs, have been marked as exhibits and submitted to this special magistrate clerk. I certify any and all photographs to be true and accurate portrayals of what I observed the day they were taken. It was ruled on June 27th, 2022, that the property owner was given 10 days to comply. The owner did not come into compliance within those 10 days and has been receiving a fine of $100 a day since July 7th, 2022. As of today, the property has accrued a total fine of $2,000 in 20 days.
Is property in compliance?
No.
Still non-compliance?
Yeah.
Okay, I'm going to find that the property remains in violation, non-compliance, so the fine will continue to run at $100 per day. The fine in the amount of $2,000 for 20 days at $100 per day shall be imposed.
Thank you.
Next case is 22-168. It's a Massey case. It has to do with debris. It's our last Massey.
Screen is off. My name is Bashir Turkzi. I'm employed by the City of Deltona as a Code Compliance Officer. This will be a Massey case number DEL 22-168, City of Deltona versus Bromagin Brian K. The property address is 1197 Acorn Court. Parcel ID number is 813002-200-270. Statutory requirements for notification of this hearing have been met by the notice of hearing and notice of code violation being sent certified mail to the property owner at the address listed with the property appraiser's records. In addition, both notices were posted at City Hall at least 10 days prior to this hearing. All of the evidence in this case, including the photographs, have been marked as exhibits and submitted to the special magistrate clerk. I certify any and all photographs to be true and accurate portrayals of what I observed on the day they were taken. It was ruled on June 22nd that the property owner was given 14 days to comply. The owner did not come into compliance within those 14 days and has been receiving a fine of $200 a day since July 7th. As of today, the property has accrued a total fine of $4,200 over a period of 21 days. The city is requesting that the fines continue at $200 per day. And the city also would like to move forward with abating the property due to the public nuisance becoming an immediate health and safety matter for the general public.
Okay, I find the property remains in violation past the deadline. $200 per day for a total of $4,200 at 21 days. Fines to continue at $200 per day is not within my jurisdiction to deal with nuisance abatement, but I appreciate you sharing that with me. I think it's probably a good idea.
Yeah, we'd like to have it on record to you.
Okay. All right.
Thank you.
Thank you. Next case is 22, we're done with the Massey's. Next case is 22-175, Exterior Services, Officer Muse. It's a new case.
Okay, my name's Dennis Muse. I'm employed by the City of Deltona as a code compliance officer, and my credentials are on file with the city. This is case number DEL 22-175, the City of Deltona versus Providence Plaza Partners LP, ECA Beligo, Providence. Location address is 1235 Providence Boulevard, Deltona, Florida, 32725. Parcel ID number is 8130-0506-0010. Violation of City of Deltona Ordinance Section 18-5, adopting the latest edition of the International Property Maintenance Code, Section 304.2, which states that all exterior surfaces, including but not limited to doors, door and window frames, cornices, porches, trims, balconies, decks, and fences, and shall be kept in sound working condition and maintained in good repair. Exterior wood surfaces and other decay-resistant woods shall be protected from the elements and decay by painting or other protective coverings or treatment. Corrective action for this particular case is remove the mold from the buildings. The statutory requirements for the notification of this hearing have been met by the notice of hearing, notice of code violation were sent certified mail to the property owner at the address listed with the property appraiser's office. Also, the notices were posted at the property. In addition, both notices were posted at City Hall at least 10 days prior to this hearing. All the evidence in this case, including the photographs, have been marked as exhibits and submitted to the Code Board hearing clerk. I certify any and all photographs to be true and accurate portrayals of what I observed on the day they were taken. The facts of the case are that this case started out actually last year, June 8th, by another officer, and a notice of violation was issued and sent certified mail for several violations. On 6/23 of last year, property management requested some time to correct the violations, most of which were corrected. June jumped to May of this year. The Winn-Dixie was being changed over to the Fresco's grocery store. An updated notice of violation was sent on 5/9/22 for the mold. Did contact Allison Morano of East Coast Management on 5/9, going over the couple of violations I still had with her that were still open. On 7/13, posted the notice of hearing at unit 1235Q. Tried to contact Allison Morano on 12/18 at 8:33 in the morning. Didn't get a call back after leaving a message. Per request of my supervisor to email photos of the violation on 7/18 and then on 7/19 to Allison Morano's email. Did not receive any response, but then heard later on that she had called and that they do have a company that will be out there, but they would not be out there until after the hearing. So as of right now, the city is asking for a violation to be corrected 30 days, or a fine of $100 a day.
So ordered.
Thank you, sir.
Next case is DEL 22-194. Officer Laracy. 194. I got it. BTR.
My name is Marion Laracy. I'm employed by the City of Deltona as Code Compliance Officer. This is in reference to case number DEL 22-194, City of Deltona versus Budget Pool Supply Whiskey City Development, LLC. Property address is 1330 Howland Boulevard. Parcel ID number is 813-038-110-270. This is a violation of City of Deltona Ordinance, Chapter 22, Section 22-4, which states no person shall engage in, manage, transact, or carry on any business, occupation, or profession within the city for which there is a local business tax required by this article or any other provisions of this code, unless such persons shall first procure a local business receipt to conduct the same from the city. There shall be no defense of non-payment of any local business tax required by this article, that the licensee did not receive any bill or notice the same was due from the city. Corrective action for the violation was to obtain a business tax license receipt or cease all business operations. Statutory requirements for this notice of hearing have been met. Notice of hearing, notice of violation has been sent to the address listed with property appraisers. In addition to, both notices were posted at the property at City Hall at least 10 days prior to this hearing. All evidence in this case, including photographs, have been marked exhibits and submitted to the Special Magistrate Clerk. I certify any and all photographs to be true and accurate portrayal of the day that I observed they were taken. This is a reactive case given to me from Deltona Fire Inspector. I met with the store manager on May 6th, explained the violation, handed her my business card. On May 16th, no license on file. I met with Heather, again, the store manager. I handed her the notice of violation, explained the date of compliance. Still no business tax receipt on file. The store owner, Yvonne, she called me. She states that she was unaware of the violation last week and said she'd have it resolved immediately. But as of this afternoon, I emailed our business tax office, and they confirmed that there is no business tax receipt on file. The city would like to request 14 days to come into compliance or a $50 fine.
So ordered.
Thank you, sir.
Next case is DL 22-203. This is accessory structures.
My name is Kristen Coulter. I'm employed by the City of Deltona as a code compliance officer. This will be case number DEL 22-203, the City of Deltona versus Joseph Rose and Judith Ann Galloway. The property address is 1528 North Normandy Boulevard. The parcel ID number is 813-0033-20260. This is a violation of City of Deltona Ordinance Section 18-5, adopting the latest edition of the International Property Maintenance Code, Section 302.7, which states that all accessory structures, including detached garages, fences, and walls, shall be maintained and kept in good repair and sound structural condition. Corrective action for said violation is to repair or remove the structure, in this case the fence. The statutory requirements for notification of this hearing have been met by. The notice of hearing and notice of code violation were sent certified mail to the property owner at the address listed with the property appraiser's records. In addition, both notices were posted on the property and at City Hall at least 10 days prior to the hearing. All of the evidence in this case, including photographs, have been marked as exhibits and submitted to the Special Magistrate Clerk. I certify any and all photographs to be true and accurate portrayals of what I observed on the day they were taken. This case was initiated proactively on May 9th, 2022, and a notice of violation was posted on that same day. A notice of hearing was posted on July 17th. No contact has been made with the property owner, and the property remains in violation today. The city would like to request 30 days for the property to come into compliance or a fine of $100 per day to be imposed until such a time that the property owner has notified the city of compliance.
So ordered.
Thank you.
Next case is DEL 22-210. Officer Brockhoff.
Mr. Richmond, I'd like to make an amendment before starting. On the cover letter, or cover sheet with the, for the exhibits, I finger fumbled and it reads FKIH, and it's supposed to only read FKH. All the notices of hearing and notices of violation were correct, though.
Understood.
My name is Steve Brockoff. I'm employed with City of Deltona as an enforcement officer. This will be case number DEL 22-210, City of Deltona versus FKH SFR Propco GLP. The property address is 3389 Vancouver, Deltona, Florida. Parcel ID number is 8130-350-90070. Violation, City of Deltona Ordinance Section 18-5, adopting the latest edition of International Property Maintenance Code, Section 302.7, which states that all accessory structures, including detached garages, fences in this case, and walls shall be maintained and kept in good repair and sound structural condition. To correct the violation, the fence should either be repaired, it can be replaced with a permit, or totally removed. Statutory requirements for this notification hearing have been met by the notice of hearing and notice of code violation were sent certified mail to the property owner at the address listed of the property appraiser's records. Both notices were posted in the property or at the city, and at the city hall at least 10 days before this hearing. All evidence in this case, including photographs, have been marked as exhibits and submitted by the code board clerk. I certify that any and all photographs to be true and accurate portrayals of what I observed the day that they were taken. This case began in December 21st when I noticed the fence in disrepair, a lot of pickets missing and patchwork. I left the door hangers, there was nobody home, and I was contacted by the resident who stated he was a renter. I asked him to contact the landlord and get the situation straightened out. No improvements were made, and I sent notice of violation to the property owner on February 10th. Extra time was given since it's an out-of-state owner. It's from Georgia. Nothing had happened, so I had set up notice of hearing. To date, I have not gotten email, phone call, or anything, no communication at all from the owners of the property in Georgia. The city would like 30 days to allow them to come into compliance because they are out of state, after which we would request a per diem fine of $50.
So ordered.
Thank you, sir.
Next case is DEL 22-211. Permit case, Officer Meade.
My name is Todd Meade. I am employed by the City of Deltona as a code compliance officer. This will be case number DEL 22211, the City of Deltona versus BAF Assets 3 LLC. The property address is 1567 La Villa Street. The parcel ID number is 813014100120. This is a violation of City of Deltona Ordinance Section 8-3, adopting the latest edition of Florida Building Code Section 105.1, which states that any owner, authorized agent, or who intends to construct, enlarge, alter, repair, move, demolish, or change the occupancy of a building or structure, or to erect, install, enlarge, alter, repair, remove, convert, or replace any electrical, gas, mechanical, or plumbing system, the installation of which is regulated by this code, or to cause any such work to be done, shall first make application to the building official and obtain the required permit. Corrective action for said violation is to obtain a permit for the concrete driveway added beyond the sidewalk area of the home. Statutory requirements for notification for this hearing have been met by the notice of hearing and the notice of code violation sent certified mail to the property owner at the address listed with the property appraiser's record. In addition, both notices were posted on the property and at City Hall at least 10 days prior to this hearing. All of the evidence in this case, including the photographs, have been marked as exhibits and submitted to the special magistrate clerk. I certify any and all photographs to be true and accurate portrayals of what I observed on the day they were taken. I observed a new driveway area on the property when doing a canvassing of the zone. My first contact with the tenant was on April 11th, 2022. The tenant and I discussed the driveway area on the property. The driveway was added to the property sometime after March of 2020. The city's files do not have a permit pulled for any concrete flat work at this time frame. Viewing the Volusia County Property Appraiser website indicates the newer driveway area. Due to the tenant occupancy, the notice of violation was mailed out to the owner on the record for follow-up. A notice of violation was sent out April 25th, 2022. Certified mailing receipt was signed for on April 30th. As of this time, no response from the owner to the code officer or to the City Hall for any kind of applications for a permit for the concrete work. The city would like to request 30 days for the property to come into compliance or a fine of $75 per day to be imposed until such time that the property owner has notified the city for compliance.
Property remains in violation.
Yes, sir.
30
Yes,
days
sir.
to comply or $75 per day fine. So ordered.
Okay, thank you.
Next case is 22224, another permit case. Thank you. Officer Suckup.
I don't want to close out the whole thing. Sorry. Sorry about the wait.
No problem.
My name is Taylor Sukup. I'm employed by the City of Deltona as a code compliance officer. This will be case number DEL 22-224, the City of Deltona versus Nava, Anya, Roman, E, Nava, Anya, Kelsey Light. The property address is 1777 Villa Drive, Deltona, Florida, 32738. The property ID, the parcel ID number is 813036170150. This is a violation of the City of Deltona Ordinance, Section 18-3, adopting the latest edition of the Florida Building Code, Section 105.1, which states that any owner authorized agent who intends to construct, enlarge, alter, repair, remove, demolish, or change the occupancy of a building or structure to erect or install, enlarge, alter, repair, remove, convert, or replace into any electrical, gas, mechanical, or plumbing system, the installation of which is regulated by this code, or to cause any such work to be done, shall first make application to the building official and obtain the required permit. The corrective action is to obtain the permit for the fence. The application must be submitted to the City of Deltona, 2345 Providence Boulevard, Deltona, Florida, 32725. The structure must meet all the requirements of the city ordinance and be approved on the final inspection. Contact our office when the permit contact with the permit number when obtained. The statutory requirements for the notification of this hearing have been met by the notice of hearing and notice of code violation were sent certified mail to the property owner at the address listed with the property appraiser's record. In addition, both notices were posted on the property at City Hall at least 10 days prior to this hearing. All of the evidence in this case, including the photos, have been marked as exhibits and submitted to the special magistrate clerk. I certify any and all photographs to be true, accurate portrayals of what I observed on the day they were taken. This case was opened March 30th of 2022 proactively. Contact was made April 3rd by the homeowner Nava requesting more time. Homeowner requested an additional 20 days after this time. Compliance has not been met. The city would like to request 21 days for the property to come into compliance or a fine of $100 per day to be imposed until such time that the property owner has been notified the city of compliance.
So ordered.
Thank you.
Last but not least, 22227. You've had a long wait.
Yes, I have.
My name is Tyler Russo. I am employed by the City of Deltona as a co-compliance officer. This would be case number DEL 22-227, the City of Deltona versus Jonathan Kyle Bacallo. I think that's how you say it. The property number, or the property address is 2976 Nobleton Street. The parcel ID number is 813-043-310-080. This is a violation of City of Deltona Ordinance, Section 18-3, adopting the latest edition of the Florida Building Code, Section 105.1, which states that any owner, unauthorized agent who intends to construct, enlarge, alter, repair, move, demolish, or change the occupancy of a building or structure, or to erect, install, enlarge, alter, repair, remove, convert, or replace any electrical, gas, mechanical, or plumbing system, the installation of which is regulated by this code, or to cause any such work to be done shall first make application to the building official and obtain the required permit. The corrective action for said violation is to obtain a permit for the above-ground pool. Applications must be submitted to the City of Deltona, 2345 Providence Boulevard, Deltona, Florida, 32725. The structure must meet all requirements of city ordinance and be approved on final inspection. Contact our office with the permit number when obtained. The statutory requirements for notification of this hearing have been met by the notice of hearing and notice of code violation were sent certified mail to the property owner at the address listed with the property appraiser's records. In addition, both notices were posted at City Hall at least 10 days prior to this hearing. All the evidence in this case, including photographs, have been marked as exhibits and submitted to the special magistrate clerk. I certify any and all photographs to be true and accurate portrayals of what I observed on the day they were taken. On May 12th, 2022, I observed an above-ground pool in the backyard of the property while doing another case. I then looked into the records of the property to see if any permit was required for the above-ground pool, and there never was. I was not able to make contact with anyone on the property until my third visit back after I had already posted the notice of violation. I spoke with the homeowner and asked what the plans of actions were for the pool. He did inform me that he was working towards obtaining the permit, but he would need a survey to get done first before obtaining the permit. He then informed me that he might end up removing the pool within the next week. I showed up a week later and the pool still was not removed. To this day, the pool still exists and there has not been any permit pulled. The city would like to request 30 days for the property to come into compliance or a fine of $50 per day to be imposed until such time that the property owner has notified the city of compliance.
So ordered.
Thank you.
And gentlemen, ladies, that concludes all of the entertainment for this evening. That was some agenda.
Thank you, sir.
No kidding. Thanks for your help. Did a great job. True. Good thing. Let me be here for a while. Thanks for your help. That was perfect. Perfect. Yeah. All right. You too.